So it's time for the inquiry to resume. Just the usual announcements. First of all, mobile phones, please, if you could turn those to silent. Secondly, if we hear the fire alarm, it is the real thing. So in that event, we go out of one of the two doors either side of the room, downstairs, and we congregate in the council's car park. Obviously, don't come back until it's safe to do so. Everybody all right with stairs? Been to the gym this morning?
I have been to the gym this morning. That's 4 days in a row now.
Gosh, oh well.
We're clapping people who exercise now. I'm not.
I'll report in tomorrow morning as well. Do you actually do anything
Okay, right. Now, in terms of outstanding issues, we're great. I think the list is almost gone now. The NHS information, I had a comment from the council yesterday. Ms Bonney, you just said you hadn't had a chance to look at it. Is there anything you want to say particularly?
No, I haven't looked at it any further, to be honest.
Well,
so
I need an answer, really.
yeah, so no, I haven't got any further comment.
Okay, thank you. The public art condition, is that a similar sort of?
Yeah.
Thank you. Right, so that, I think, knocks off everything now. I think we're up to date, unless anyone can think of anything else that we haven't got. Thank you. Now, the only other thing we will need to discuss before we finish is the Section 106 agreement and how we're timetable for dealing with those. So we need to consider, first of all, when we're going to get the engrossed documents. They're not going to change apart from being dated. So that's the first date we need. And I'll allow a certain time for any final comments, given that there's been so many changes. And that's by anybody obviously not party to the deed. So it's basically the 5 parishes and the action group and I suppose National Highways if they had anything to say, but hopefully not. And those comments must only be sort of things that haven't been discussed and that I haven't had your views on. So it's really any particular changes. And then I'd allow a sort of short time if the signatories to the Section 106 had a response. I would hope not. And then a further short period of time till it can be signed by everybody. So there's a sort of 4 dates that we need to set. So really, I can't sort of think about those until we know when we're going to get the document. So that's the priority for you to tell me.
Yeah,
I will share that.
I'll come back to you tomorrow on it.
All right.
Thank you.
I'll share those 4 points with KCC and the council now so that we can try and reach an agreement on those points.
Well, we'll have to, yeah.
Yeah, no, but
otherwise
as fast as we
I'll
can.
set the timetable otherwise. Right, all right. Well, you might not. I just want to say, can we all just listen to everybody's closing submissions respectfully? And I'm not looking at anybody, but there was too much chat yesterday. And
If
I don't want any excuses, thank you. If you want to chat, you have to.
No, it wasn't that. It was just to say it was certainly no intention from our side to be anything other than respectful. It's the reason that we were whispering was because we've actually got to try and respond to all of these
I do
things.
understand that.
And so we are working as we go.
Yeah.
But we're going to keep it to WhatsApp today.
We weren't the only ones anyway.
No, okay.
Right, okay. So today then we are going to hear the Duchy first of all, Dr. Bose. Yes, hello. So you've put in your closing submission and we'll hear from you in a minute. And then we've got the beautiful tome of the council. And it's 20 judgments, at least one which is one of my successful ones. Thank goodness. Actually, I've been involved with at least 2 of them, but one on a redetermination, which was also not challenged, I hasten to add. Yes, we'll look forward to hearing all about those a bit later. And Dr. Bowes, you've just restricted yourself to 2 actually, but a bit more manageable, isn't it? All right, so we will have breaks obviously in the day, but we'll hear yours anyway first, and then we'll see. It's not very long, so we'll probably start with council after that. All right, so is there anything else anyone wants to raise before we start? No? All right, thank you very much, Dr. Bowes.
Thank you, Madam. As we said in opening, the Duchy does not object to the applications. Instead, as the promoter of the South East Faversham scheme, the Duchy appeared at the inquiry to ensure that all relevant matters were addressed, and importantly to ensure that this scheme was held to the same high standards of design and sustainability as its own. Madam, you will have noted the Statement of Common Ground signed on the 26th of September 2025 with the applicant and the Duchy. That records the agreement that there would be capacity for both Highsted Park schemes and the Duchy's scheme at South East Faversham, while still leaving a need for further large-scale development elsewhere in the borough. Our position is that there are 2 matters which merit careful scrutiny. First, the design of the southern scheme and the highways impacts of both. Turning to design, Mr Sutherland gave written evidence that the project drew from exemplar projects, including the Duchy's own scheme at Poundbury. However, he accepted in his oral evidence that he had not in fact applied anything from Poundbury in the master planning of Highsted Park. He accepted that principles of a well-designed place apply to the master planning exercise, not just to detailed design, including a coherent pattern of development. Looking at the parameter plan, however, the southern scheme clearly fails to meet that criterion. First, the only part of the built form of the southern scheme which adjoins Sittingbourne is Highsted North. Second, to get from Highsted North to and from the rest of the scheme, one has to go across the Southern Relief Road. Third, Highsted Village East and West are separated by the road. And finally, the existing historic village of Rodmersham is inset from the master plan.
Actually hear any evidence from the Duchy on all this? You didn't give planning evidence, did you? Or design evidence?
Well, we put in our
highway evidence.
proof, and we cross-examined on the basis of that proof Mr Sutherland.
All right, okay, go on then.
Well, it wasn't me, I should say, it was Mr
No, I know.
Warren who was
No.
cross-examining, but I've
Okay,
made
it
submissions
was
on
quite
that.
a while ago, so I'll give you the benefit of the doubt then.
Yeah,
All right,
11th of March 2025, I put in the footnote.
Oh, well, there you are then.
Thank you. So we say, contrary to the objectives of the scheme to exhibit a pattern of growth that is sympathetic to the historic evolution of the wider area, the scale of Highsted East and West and Oakwood necessarily do not echo or reflect the character of the existing Highsted and Rodmersham villages. Mr Sutherland said the scheme disassociated the historic villages with the scheme, which is a new concept and layout, and when asked what about the scheme was sympathetic to the historic evolution of the villages, Mr Sutherland accepted that a different form of development was coming forward with a fundamentally different scale. Mr Sutherland explained that the new villages in the southern scheme of Highsted, Oakwood and Tyneham were to be seen as 3 interconnected villages, but he had not considered whether a smaller scheme with 1 or 2 of these smaller villages rather than all 3 would be justified in design terms. Given those issues, Mr Heifer was right to invite you, Madam, to impose conditions to secure the highest quality of urban design, infrastructure and sustainability standards, or, if you felt unable to do that on the available material, require the applicant to return via a further application with a more considered and detailed submission informed by the same level of evidence and community engagement as the South East Faversham scheme. And deciding between those 2 courses of action, Madam, you will of course be aware of the recent Supreme Court judgment in CG Fry, which emphasised that where an outline permission has been granted, it must be presumed that some element of development must be acceptable on the site within the ambit of the outline permission, and it follows that if there is an element of doubt that a well-designed scheme could be achieved within the parameters of the outline permission, the appropriate course would be to withhold consent rather than rely on the proposed design code condition. So turning to what I hope I am on very safe ground about, on highways, the Duchy submit that there are 3 points which require careful scrutiny. First, there is the applicant's approach to the reference case on the southern scheme. The applicant has taken all permissions and the draft local plan allocations together with an assumed windfall rate into its reference case. Mr Wilde accepted that in so doing, his reference case went beyond the policy guidance in the PPG, which is to give appropriate consideration to development which is consented or allocated, where there is a reasonable degree of certainty it will come forward in 3 years. Mr Wilde's initial justification was to say that all the PPG was suggesting was that consented and allocated schemes should not be ignored from a reference case, not that the reference case should only comprise consented or allocated schemes. However, with respect, that is not a sensible reading, we say, of the paragraph. The guidance is directed towards applying the cumulative assessment tests of paragraph 116 of the framework. It would be bizarre if, having taken the trouble to define cumulative impacts as being development with a reasonable degree of certainty of coming forward in 3 years, it actually intended that development without any of that certainty were to be counted for the purposes of cumulative assessment. In his later answers, following interventions from my learned friend, Mr Wilde suggested that the December 2024 MPPF superseded the PPG and thereby presented a justification for the approach he had taken. That is clearly wrong. First, the transport assessment was completed years before the December 2024 MPPF, and so cannot have formed the basis for the methodology in the TA. Second, it cannot be said that the approach of the PPG, i.e. considering only consented and committing schemes with a reasonable prospect of coming forward in 3 years, is unreasonable, especially considering it is the very approach that the applicant itself takes for the northern site. Third, it must therefore follow that even if the applicant's approach is a reasonable future scenario, in failing to present the PPG approach for the southern site, the applicant has failed to assess the scheme against all reasonable future scenarios contrary to the framework. Whatever is the correct way to read the PPG and the MPPF, the applicant's approach clearly fails to provide the necessary environmental information required to be described in an environmental statement. That is because Regulation 18.4b of the EIA Regulations 2017 provides that an EIA must provide the information required for reaching a reasoned conclusion on the significant effects of the development. By seeking to include a reference case, which includes development which is not consented or allocated, the applicant has skewed the description of significant effects by uplifting the baseline or benchmark against which the significance is described, by including development in that baseline about which there is no certainty whether it will come forward, when or where. Accordingly, the applicant has failed to provide the necessary material to reach a reasoned conclusion on the significance of the highway impact arising from the southern scheme, because it has failed to describe the impact by reference to a robust reference case. That is materially different to the situation in Boswell, about which you're going to be informed by the appellant. There, the Court of Appeal held at paragraph 79-81 that there was no requirement to contextualise the significance of the effect by reference to a benchmark. Rather, it was a judgment for the decision taker. But here, by contrast, the applicant has presented its predicted significant highway effects by comparison to a benchmark or reference case. It follows that, in its view, the significance of the highway effect is to be understood by reference to a benchmark. The Duchess complaint is that, having chosen to do that, it is incumbent on the applicant to fairly describe the significance of the predicted effect against development which is existing and or approved. That is because that is the threshold of certainty against which the EIA regulations choose to require assessment. See Schedule 4, Para 5E. Mr Wilde accepted that he had not presented that reference case for the southern site, but accepted that it was technically possible to do so. Indeed, that must be correct, as it has been presented for the northern site and for the junctions in Mr Wilde's rebuttal. The second issue, there is the applicant's assumption that Highsted Park Scheme plus 4,000 units from other schemes will replace the assumed windfall of 6,014 in the Regulation 19 plan. The Duchy submits that assumption is not robust, and that in all likelihood, most if not all of the Regulation 19 assumed windfall of 6014 will be delivered before Highsted Park comes on stream. For one thing, the Statement of Common Ground with National Highways explains a default 6 years for consent for the highway infrastructure works, which were necessary to complete before Highsted could be occupied. Whilst Mr Weil was at pains to say that that was only a default timeline, there was no bespoke timeline before the inquiry which suggested a shorter consenting process for the ministerial consent and onward project delivery, and no evidence from which that conclusion could be inferred. Indeed, when invited to do so, Mr Weil did not suggest an alternative timescale. Third, the applicant's interpretation of paragraph 116 of the framework was legally incorrect. As Mr Weil repeatedly said, he was focusing on whether the difference between the baseline and the scheme was severe, rather than whether the residual cumulative situation was severe. That question has been litigated in Bovis Holmes against the Secretary of State for Communities and Local Government, which is one of the authorities you have, Madam. One of the issues before the court, see paragraph 26, concerned whether the inspector had misunderstood what is now paragraph 116 of the framework, then para 32, by finding that the MPPF, quotes, refers not simply to the additional impact of the scheme, as had been asserted by the appellants, but to residual cumulative effects, implying that it is the cumulative effect of all expected development, which must be taken into account in context, rather than just the individual contribution of each development in turn, which is likely to be, as in the present case, marginal. The judge, Mr Justice Holgate as he was, found that it was unarguable that the inspector's reasoning revealed any misunderstanding of the MPPF. He found at paragraph 32 that, quotes, the existing levels of congestion were relevant and not irrelevant, as some parties had contended, to determining whether there would be severe residual, emphasised cumulative impacts in breach of para what was then 32 of the framework if proposed development were to go ahead. Now, whilst it's important, Madam, to understand that judgment was on permission only and therefore not binding, it does demonstrate that approaching matters as Mr Wild suggested would likely lead you into legal error, given that was the view of two High Court judges, both Mr Justice Holgate and Mr Justice Lewis on the papers. Turning then to the junction performance. First, there's junction 20. Mr Wild accepted that if the 16 PCU were used instead of 12 to 13, then queuing would extend a further 18 metres over the stop line. Then there's junction 32. Mr Wild accepted that the acceptability of this junction relied on 120 cycle time, but agreed that the TfL guidance suggested up to 90 seconds was preferable. Whilst the guidance is not binding, there has been no safety audit of the proposed junction performance with 120 cycle time. Mr Wild accepted that if a 90-second cycle time were used, that would put the junction over capacity. Whilst he indicated there would be a measure of diversion to the new relief road, there was no evidence about that rate, and therefore no weight could be placed on that assumption. Junction 39, Mr Wild's analysis here all turned on focusing on the difference between the existing and proposed, rather than focusing, as we say is required, on the residual situation. The residual effect would be a 10-minute delay, which is on any view severe. And finally, the M2 junction, that's junction 7 Brenley Corner, the predicted queue length difference is between 385 to 462 metres longer than existing, extending back from the slip road onto the carriageway. That will clearly give rise to dangerous manoeuvres where people waiting in the stationary carriageway waiting to enter the slip change their minds and move suddenly onto a lane with traffic travelling up to 70 miles an hour. Similarly, a person on the carriageway, knowing they want to exit, has to then pause on the carriageway to turn into what has become a slip road. Mr Wild accepted that these represented highway risks, which were an indicator of a severe effect. Now, given he has applied the correct threshold, Mr Weaver's assessment that there would be a residual severe impact arising from junctions 20, 32, 39 and the M2 junction should be preferred. The applicant has failed to supply the necessary baseline information for an assessment of the impacts of the southern site, which complies with the policy and the law, Even the limited information which has been disclosed on the junctions 20, 32, 39 and the M2 has revealed a severe effect at those junctions. Accordingly, it is not possible to determine whether the policy at paragraph 116 in the framework has been met. And finally, Madam, drawing all that together, whilst it doesn't object, the Duchy considers that you, Madam, have insufficient information to conclude the scheme would represent good and sustainable design and would have a satisfactory effect on the highway network. The Duchy therefore invites you, Madam, to request that further information, or insofar as you felt able to do so, impose conditions to require further information to be submitted at the detailed stage. Alternatively, if there is a doubt about whether a well-designed scheme could come forward without residual severe traffic impacts, the best course would be to withhold permission at this stage. Thank you.
Thank you very much indeed.
Thank you, Madam.
Right, okay, thank you. So we're now going to go on to council.
Would it be possible? I'm so sorry to intervene just very, very briefly before Mr. Pereira starts, but I feel unfortunately I've got to, because I did yesterday in exactly the same circumstances, and it wouldn't be right to only do it for the Rule 6 party and not for the council.
Oh, yes.
Before the Rule 6 parties closings yesterday, you'll remember that I said a load of things to do with the Wimbledon judgment, and
Yes.
the critique that I raised, that was responded to, but I'll just go over it again just so everyone remembers, was the idea that, albeit there was no planning evidence from the Rule 6 parties that went to whether or why deliverability should feature as a material consideration in the balance, the closings had sought to introduce these matters of planning judgment, and the response from the Rule 6 parties was these are legal submissions, and that was the back and forth, and I said it was inappropriate to do just by way of closings. I make all the same points that I made yesterday, I make now again in respect of the council's closings, and in particular the paragraph numbers 35 to 45, where the council now invites you to, I'm going to get the phrasing right, they say that matters that bear on deliverability, quote, by definition go to the planning balance, could be relevant to the planning balance, might be said to be relevant to the planning balance. They put it in different ways. And long story short, some of the reasons that they give are the same reasons that that the Rule 6 party alight on in their closings. But the reason that I raise it now is that it's the same objection. Mr. Dygan was absolutely clear that he'd given no weight to deliverability in his planning balance. It's quintessentially a matter of judgment as to the extent to which deliverability features in a planning balance. And the council has its planning judgment set out through its planning witness on that question. So to the extent that the council is now asking you or the Secretary of State to feature a load of other things in the planning balance that weren't featured by Mr. Dygan in his planning balance, it's going outside the evidence that I was able to test with them in cross-examination. And these are, in the end, notwithstanding what was said yesterday by the Rule 6 party's barrister, Mr. Barnes, these are questions of planning balance and judgment. They're not questions of legal submission as to what goes into a planning balance or how much weight it gets. So we will, in just the same way as said yesterday, we're going to deal with it in our closings by pointing out, we'll respond to it as best we can. But I do note that it's unfortunate in both cases, because if the Rule 6 party and or the council had actually had evidence on deliverability as a material consideration, I would have asked questions about it. We won't be prejudiced because I'm going to say things about it in closing, or Ms. Buono actually might be saying things about it in closing tomorrow. But you are, just to be clear, on our submission, both from the Rule 6 party and the council, you're getting fresh evidence in these closings on this question. And both parties have essentially alighted upon Mr. Young's case to take points that's not actually in any of their evidence.
Okay. you are satisfied.
I am. I'm saying it. I wasn't even going to say it, other than the fact that I said it yesterday, and it wouldn't seem. It would. I don't want to make it seem as if I'm only making points at the Rule 6 party's
No.
expense. It's the same point as yesterday, and so I'm repeating it because the council have done the same thing. But I am satisfied that we are not procedurally prejudiced, because all the things I want to say, I'm going to say by way of response in, or Ms Bueno will say in response in closings. But nonetheless, it's important because it's something you're going to be reporting on, but we're clear on what we think you've heard evidence on and what you haven't heard evidence on.
I see. Okay, that's fine.
Thank you. I'll respond to that briefly before carrying on. My learned friend should have trusted his initial judgment and not said anything, because we've been clear all along on why Mr. Dygan doesn't feature it in his planning balance, but nevertheless why it's a matter we're requesting a finding on. And indeed, this was explored in evidence in chief, and it was explored in cross-examination by both parties, so there is evidence on it, and that is highlighted in the footnotes, which also have hyperlinks to the relevant part in the transcript, so you can check for yourself. But the simple point is, it doesn't feature in Mr. Dygan's planning balance because the council accepts that the scheme is viable. That's always been its case. But faced with an inquiry where others don't, and therefore the issue is before you, and it goes to the planning of the area and the position of the emerging plan, it's important for the council that a finding is made on it, and therefore we've set out the basis on which, given the case law, it may be relevant to those judgments. And we've been very transparent about that, both in me clarifying my case, the council's case, which I did several times by way of intervention and clarification, and in the way we've presented it. So I don't accept the criticisms that are made, but when we get to the relevant parts, you will see that the evidence is very clearly cross-referenced. It's not new evidence.
That's fine. I mean,
and
we'll leave. I would no
and
point
there
going
we
back over it, but that's understood.
So, without more
All right.
ado, can I just say something about the closings? I think the parties also have access to an electronic copy. The electronic copy is hyperlinked through the indexes, and you will also find that many of the references to the evidence in the footnotes on issues, for example, such as viability, where we anticipated something might be said, are also hyperlinked, so that you can check in the YouTube video whether things are there or not.
Okay.
I just want to say formally, obviously it's a joint closing and it's been checked and edited, and not only by myself but by Mr. Dygan and his team, but Mr. Rhymes deserves the lion's share of the credit for taking the clay and putting it all together, and in particular for the style of the presentation. So he's had in mind not only doing a kind of a good job, but also helping you. So I hope very much that you'll find it helpful, even if you don't agree with all of the points that are in it.
Thank you.
So we're going to share the reading. There will be parts that we will speak to rather than read out, but without further ado, I will start, if that's okay.
Yes.
Thank you. So, introduction, first of all. No one living in the gentle village of Rodmersham Green, no visitor exploring the mill pond at the Tong Conservation Area, no rambler wandering through the Kent Downs national landscape and being propelled back in time by the Grade 2 star Bexton Court, would ever imagine that emerging from the future in the very places they stand was an urban relief road, thousands of homes, a major motorway junction, and all the familiar trappings of busy urban life that come with them. Many people don't like change. Trollope's Lawrence Fitzgibbon hated it as a rule, but change is neither virtue nor vice. It's movement, sometimes forward, sometimes astray, and 16 weeks on, the central issue facing the inquiry remains the same. The proposals, the council said in opening, will undoubtedly be transformational, but in a good way, and at what cost? The combined schemes are so big that they will drive the local development plan rather than the plan leading the way. The applicants make no bones of this. They celebrate their ambitious vision and laud their potential for transformational change. Some might welcome this. They might say, if the applicants are planning for this growth and SBC is not, let them get on with it. If the Secretary of State wants to build, who cares that it arrives under the wrapper of development management and not the local plan process? What an arid distinction to lay in the path of our moral obligation to build more homes, they might say. The Council sees the issue differently. To take up the gauntlet thrown down to the local planning authority and perhaps the planning system as a whole, we must thoroughly examine the benefits of the schemes for at least two reasons, one democratic and the other practical. The democratic one is that normally such growth would be brought through the plan process, with various growth options weighed against each other and consulted upon in a community-led process. Angela Rayner recognised that development coming forward outside the plan means much less public engagement and fewer guarantees that it's the best outcome for your communities. There is a democratic consequence to a developer chancing their arm through development management. We owe it to the public to ensure that these schemes really do deliver the benefits they proclaim. And there's a practical reason. The sheer scale of the development means there's little room for error. At its heart, this case is not about two planning applications, it's about delivery of an alternative strategy for growth in Swale. If that strategy is a poor one, Swale's future will be locked into it. It will realistically choke genuinely sustainable vision-led developments which could have better met the needs for housing or employment land. The effect of strategic planning through speculative development is that alternatives can never fully be tested. The application can be assessed on its merits, but never fully compared against different solutions and options that might otherwise have emerged. In many respects, this case is not about Highsted, it's about the future of Swale. We repeat the point made in opening. At the time of the call-in, the only responsible and lawful course for the planning authority was to refuse the schemes as a whole. Some of the many issues of the reasons for refusal are now resolved, but often subject to very significant caveats. National Highways does not object on strategic highways grounds, for example, as long as the M2 junction passes subsequent consents and is actually delivered. That some objections have been overcome does not indicate that proposals should be approved, but rather it highlights the scale of substantial objections that existed and reminds us to be attentive to those that still remain. These 16 weeks have permitted this inquiry to move beyond the promises in the glossy prospectus of the overall schemes to their granular details. The Council's position is that they are clearly harmful and warrant refusal. In a nutshell, the Council makes the following overarching three submissions. Development plan. The schemes are fundamentally contrary to the principal yardstick by which Parliament requires planning applications to be judged. Footnote 7 policies. These proposals fundamentally and irreversibly strike at the assets which the Secretary of State has singled out for particular protection in his national planning policy. As such, they do not even get to the tilted balance. And, for the planning balance, seen in the round, the harms exceed the benefits significantly and demonstrably, if need be. The planning balance is in favour of refusal. We then express the structure. There are some overarching points, then common ground, the battleground, the planning balance, something on the 106 contributions, and then conclusions. And now I'll hand over to Mr. Rhymes. Thank you.
Madam, continuing now on page 9, there are 6 overarching points, and I'll start with the first one. Paragraph 9. The epoch-defining housing crisis is a core generational problem which this government has committed to resolving and which the planning system needs to face. To that extent, the need to provide housing, the what is broadly agreed, but the way in which the government seeks to respond to that crisis, the how, is just as important. Sure. Planners talk of the presumption in favour of the local development plan. That jargon obscures both its importance and its function. It is the golden thread of planning since the halcyon days when the right to develop was first nationalised in 1947. It is the concrete expression of the right which Parliament has conferred upon local communities to have a say in how their environs develop. The hard choices that need to be made to do things differently, the call to arms of which the Secretary of State speaks, are both to be achieved through the local planning system in the 1990 Act. As the government said in its response to the consultation on the 2024 MPPF, the plan-led approach is and must remain the cornerstone of the planning system. We must build, baby build, but without a planning inferno. The framework is alive to this. It does not sacrifice all principle on the altar of 5-year housing land supply. In opening, the applicants pointed to the ministerial statement decrying the acute and entrenched housing crisis. That very statement has a pillar on building in the right places. The challenge is not just to build, but to build well, not just to live, but to live well. The way to do this, according to the Secretary of State, is the framework's unifying principle of sustainable development. That principle is the lodestar of the framework and offers a principled means to address the housing crisis. It provides, in some circumstances, a pressure valve in the form of a tilted balance. The broad architecture of that tilted balance, at least for our purposes, is broadly unaltered following the government's manifesto pledge to deliver 1.5 million homes. It is through and not in spite of the vision of sustainable development that such pledge should be met. To give true expression to the principle of sustainable development, the framework must be approached as a whole and not in silos. It is of course the case that the development would boost the supply of homes and support the economy. It would be a tall order for an 8,400 dwelling scheme with roughly 37 hectares of employment space to not do so. Compliance with the framework is not a mathematical exercise totting up compliance with individual chapters. The individual chapters give expression to the overall vision of sustainable development. Where a development does not comply with that overall vision, it will be difficult, Swale says, to find it consistent with the framework, even if it does cohere with individual chapters. The fabric of the framework should not be taken as individual strands, but like life, as a mingled yarn with good and ill together. In that respect, the framework is much like the local development plan, which marries ambitions for growth with nuanced policies of restraint. Its settlement boundaries, for example, are themselves contingent on development respecting the landscape, historical context, and tapestry of place. Much of the conflict with the local development plan arises not because of the settlement boundaries that it endorses, but because of the harm to the planning assets which it seeks to protect through those and other policies. The questions asked by the Secretary of State are necessarily siloed into the various chapters of the NPPF. If this scheme is delivered on the scale it is promised, it will have real impacts, good and bad, for local communities. The need must take stock of the location, scale, design, and timing of the development. This calls for a balanced assessment of the framework read as a whole and the local development plan.
Thank you. And the next general point. Swale has continued planning. A core tenet of the case against the council is that it has stopped planning. Light barbs are peppered through the applicant's evidence. This has a jingoistic appeal but little substance. Yes, Swale, like many authorities, does not have an up-to-date plan. That naked fact overlooks its concerted efforts to plan positively for growth in the last years, and which we summarise below. And this is important to the council, so I will read through it. Following adoption of Bearing Fruits, Swale Borough Council immediately began work required to prepare a new plan. The local plan panel was established in 2018 to guide the process, meeting 29 times between 2018 and 2022. Members considered options for growth, site selection, and the potential for new settlements. Various submissions were received through the New Garden Communities prospectus, including one corresponding to Highsted Park, and were assessed in 2 detailed stages in the famed PBA reports. After careful review, the local plan panel in October 2019 resolved that major new developments would be tested through the issues and options consultation and considered alongside other options. Thereafter, the council advanced successive stages of plan preparation under an approved local development scheme. A preferred spatial strategy was identified through the local plan panel and cabinet in July and September 2020, focusing growth around established centres such as Faversham rather than through garden communities. That change, of course, was a departure from the recommended PBA reports, but it remained within the council's democratic remit to do this. Consultation on the pre-submission plan followed swiftly in February 2021. This was well within the timelines contemplated by Bearing Fruits. Progressing it thereafter proved difficult. Communities were concerned about their lack of involvement. The direction of planning policy changed substantially in the July 2021 framework. The applicants brought, and then withdrew, a legal challenge. Following internal committee restructuring, work has continued under the auspices of the Planning and Transportation Policy Working Group, to whom a revised LDS was presented in July 2022. Detailed traffic modelling was required, which had knock-on effects on this timeline. Progress was then further stymied by the 3 changes of Secretary of State, and acronyms, fundamental legislative changes affected in the Levelling Up and Regeneration Bill, and uncertainty in the National Planning Framework. Far from sitting on its hands, SBC decided in 2023 to progress the underlying evidence base for the local development need and potential, but defer the actual plan making until the dust had settled on the direction of travel for national planning. A new LDS was approved by full council in July 2024. In August 24, the Planning and Transport Policy Working Group provided a steer on the draft plan, again focusing growth around Faversham and not Highsted. Since the Highsted Park applications were called in, progressing the draft plan itself has been put on pause. But first, Swale has not stopped. Officers remain hard at work on the evidence base. And second, the parties agree that this was a reasonable course to take, and Mr. Bashforth in cross-examination accepted this approach was sensible and fair. The council remains firmly committed to plan making, and as at present, the full council has approved a list of employment sites for the emerging local plan. The council has agreed the approach to setting housing targets based on the government standard method. An updated LDS, which is in the inquiry documents, was taken to full council in July 2025, and further explanations as to timings are at that inquiry document. The transport model has been completed. The reference case and base case for the transport model have been agreed with National Highways and KCC Highways, and so on. I'm not going to read the rest of that paragraph. Paragraph 25. Officers make no bones of the fact that the timing will be challenging, but the challenge reflects Swale's commitment to get things done. Far from having stopped planning, Swale has acted pragmatically and transparently in seeking to progress its local plan through often turbulent periods of national and legislative change. It has a credible and sound path forward, and one which, but for these applications, it would have continued to deliver.
Turning now to the third overarching point. Virtually all aspects of the combined schemes are in outline. The form of the housing estates, the massing of the employment space offering, the nature of the much vaunted open space are subject to all but the most light touch of parameters. Of the cast deployed over the course of the inquiry, one member is remarkably absent, the detailed road design. Its absence is all the more striking given that it is a fundamental part of the development proposals and tightly bound up with the promised game-changing benefits. Indeed, even the most worked-up part of the road, the M2 junction, has no detail beyond a proof of concept, with detail to come forward in a separate consenting route. The applicants can lawfully bring the applications forward on this basis, but there are consequences to putting on Hamlet without the Danish prince. They relate more broadly to the outline nature of the scheme in all its guises, but they are the most acute for the road. We go through three consequences of this. First, as a matter of law, the decision maker must assume a reasonable worst-case scenario for the road infrastructure. This is EIA development. The EIA regime is procedural in its protection. It aims to ensure that any consent is given with full knowledge of the environmental cost. The decision maker must reach a conclusion on the significant environmental effects and, critically, then integrate that conclusion into the decision as to whether to grant planning permission or not. This is a fundamental, definitional, and core part of the EIA process. If the decision maker were to fail to take the worst case realistic scenario for the development, the likely extent of its impact will not truly have been taken into account or truly integrated into any decision to grant consent. This applies to the full gamut of the combined schemes, the extent of the harms, the success of the mitigation, and all other pertinent matters. This is of particular importance for the road infrastructure in the southern scheme, which, Swale says, presents multiple axes of harm to a wide range of assets. The outline stage of the road is not a defence to criticism, but a factor which must legally be carried through and integrated into the planning balance on a worst-case realistic scenario. To draw out the Hamlet metaphor, if in doubt, assume something is rotten in the state of Denmark. Second, the harms from the road should not be underplayed, consciously or otherwise, because they will come forward at a later stage. The decision makers must not overestimate the practical benefits of the road infrastructure, which can already be appreciated at this stage, at the expense of the no less real harms which will only materialise and only truly be known later. Now that the technical feasibility of the road infrastructure is not disputed, the applicants can already claim the principal benefits on which they rely. Such benefits exist and can be credited for even when the road design is, as of yet, an abstraction to be dealt with in subsequent consenting stages. By contrast, the principal harms on which Swale relies are at core perceptual ones, like the impact of the road on visual or oral dimensions. They are intimately tied up with the physical structure and operation of the road, of which we have precious little detail at this stage. The challenge for the decision maker is therefore to focus not only on today's more tangible benefits, but the harms that are to be, or indeed not to be. The third, even assuming the delivery of the schemes as a whole, on the assumption that they are both granted permission, the lack of detailed design at this stage for the roads has obvious implications for the timing of the combined schemes. The road is a fundamental part of the scheme as a whole, which must be delivered first. No one, least of all Swale, has a crystal ball, but the route forward is instructive. Madam, I don't propose to read through those sub-paragraph, but we've essentially set the route forwards, and I've checked with National Highways closing submissions, and they appear to cohere. Starting now at paragraph 33. There are, of course, ministerial statements urging celerity in infrastructure development, but it is hardly a secret that planning is beset with delays, despite the best intentions. The rapid timescales reflect optimism, not experience. The applicants' response on nearly all objections related to the infrastructure are that they are wrong-headed because they have essentially already figured it all out, or that it is an exercise in unnecessary hand-wringing at this stage because they can figure it out down the line. Either approach carries real risk. A final crack at Hamlet. A degree of hubris is required. There may well be more things in heaven and earth than are dreamt of in the applicant's philosophy. Speed. The precise timings of the road are not for Swale Borough Council, but there are implications to timing on the planning balance which we consider below.
Viability and deliverability, and I think this is the part of the closing that caused my learned friend to make the comments he did. The applicants contend there are no major barriers to delivery to the infrastructure necessary to support the proposal's housing growth and its strategic transformational benefits. The applicants have been taken to task on that point over 3 weeks of evidence. The council's position on the substance of that debate is that the scheme is technically viable. That is why delivery does not feature in Mr. Dygan's planning balance. That said, other parties to the inquiry have questioned the viability of the schemes, some from the outset in their statements of case. Given that the Secretary of State is now seized of this controversial issue, the Council's position is that the Secretary of State should reach a conclusion on it. We make some broader observations on the legal and factual material before the Inspector on this point. First, legally, there's no doubt that in law, deliverability can be a material consideration. And I'm not going to read through all of the Roman 1, 2, 3 there, but the essential point is, as said at 37A, non-planning impediments to a scheme coming forward can be considered by the decision maker if it affects the planning balance. And those cases, the first two of which are discussed in Save Wimbledon, are just there to highlight that point. And I understand that to be common ground with everyone at the inquiry, that it can be, and it's a matter of planning judgment. So I'm going over to page 17B. As a matter of logic, deliverability is not generally likely to be relevant to the planning balance. Planning considers whether the scheme, on the assumption it does in fact come forward, is acceptable in public land use terms. If it doesn't come forward, the benefits won't be realised, but the harms will not come to pass either. So it would generally be irrational to treat the risk of delivery as an adverse factor on its own right, in the same way as it would be to give positive weight in its own right to the delivery of the scheme. There's no closed category of cases where deliverability is necessarily relevant or irrelevant. That's Wimbledon. And on D, cases where deliverability may be relevant may include those where sites would compete for a single opportunity to meet need, where planning benefits relied upon are time sensitive, or because the development meets a pressing social need. So 38 then, on the facts. This is a case where it would be open to the Secretary of State to conclude that the deliverability of the scheme goes to the planning balance. And we draw the following strands of evidence together. Mr. Dygan's explanation in chief that a grant of planning permission would influence, if not dictate, the direction of growth. It will result in the sites being allocated in the local plan. There are on any view considerable applications which would deliver large quantities of the planned need for housing and employment. It would be harmful in planning terms for such allocations to be made on the basis that they could meet that need if in fact there are obstacles to their delivery. And related to this, B, the PPG allows the assessment of viability of strategic sites before their inclusion in a local plan in recognition of the fact that they're critical to delivering strategic priorities. Here the applicants rely on the promise of strategic benefits to support the merits of their applications. They should not be excused the same level of scrutiny because they've avoided the plan-making system. Moreover, deferring viability assessment to the plan-making stage would not be an answer. Mr. Bashforth accepted that viability would not likely be revisited again at the plan making stage, and you've got the reference to that there, including a hyperlink to that evidence. But suppose it was subsequently assessed and the combined schemes were subsequently found to be undeliverable, that would have a serious knock-on impacts for the preparation of the plan, as alternative ways to meet need would have to be found. It would in any event be saddled by the prospects of a large strategic site, whether allocated or not, that might or might not be delivered. As Mr. Dygan explained in chief, if there is doubt and you have consent, but there are questions regarding deliverability, that would be unworkable. And then finally, Mr. Bashforth tentatively but rightly accepted that delay in the emerging local plan would itself be a source of planning harm. He also accepted that in his assessment of the planning merits, he'd included the pressing need for homes, affordable homes, and a deliverable solution to transport. Standing back, delivery might be said to be relevant to the planning balance in the following three ways. First, you may conclude that there's planning harm in and of itself if the development were to be approved, but then ultimately stall due to planning constraints, due to non-planning constraints, because of the impact on the delay to the local plan, as Mr. Bashforth accepts. The prospects of non-implementation might create a rather different balance between benefits and impacts. That's a quote from one of the cases. Secondly, the weight ascribed to the benefits of the scheme are in no small part tied to the pressing social need for their delivery. Miss Dickinson's evidence, for example, reads as a paean to timely build-out rates of the schemes, to which she refers no fewer than 15 times. She accordingly places substantial weight on the actual and efficient delivery of the housing and affordable housing. Mr. Bashforth, as above, accepted that he placed weight on the combined schemes meeting pressing need and offering deliverable transport solutions. The planning statement does as well. Mr. Bashforth sought to parry this argument by positing a distinction between time-limited benefits and chronic needs. That's not, we say, well-founded in the authorities, and true, some concern benefits which are by their very nature time-limited, like the Holocaust Memorial, but not all cases do. Deliverability can be relevant in a case where the development is said to make a timely contribution to chronic need, such as, e.g., the non-planning impediments to the crematorium in that case, which were lawfully weighed in the balance because of the pressing and chronic need for a crematorium. And in Newcastle, that case held that the deliverability can be relevant if the merits of a proposal depend upon the development being desirable in the public interest or there being a need for the scheme. The gist of the cases is that the chronic and pressing need will still remain if the applications are delayed because it's chronic, but the benefits are lessened as they don't meet the pressing need. Hence, the planning balance is affected. If Mr. Bashforth accepts, as he did, that there is a pressing need for homes, affordable homes, and deliverable solution to transport to be weighed in the balance, this case falls well within the established precedents where delivery could be relevant to the planning balance. Third, deliverability is also relevant given its implications for how other parts of the scheme are assessed. The Council recognises that its emerging local plan is delayed. No alternative to meet accepted demand for housing or employment land is or can be put forward at this stage. But if the scheme stalls and the timelines of its delivery of employment land recede, the prospects of there being alternatives in an up-to-date plan become sharper. Such alternatives may, for example, not come at the expense of highly protected assets such as the national landscape or ancient woodland. These all are matters which by definition go to the planning balance. To be clear, none of the above invites you to determine anything other than the application before you or the Secretary of State when making his decision. It does not invite a refusal on the basis of some future applications. Rather, this is a case in which delivery goes to the planning balance of the applications before the inspector for the reasons given above. And again, we stress that's a matter of planning judgment. And again, to be clear, in other words, the outcome is one that's aligned with the applicant. The outcome is, even if the route that we're setting out here may be different. But again, to be clear, the Council's position remains that the schemes are viable and so viability is not a bar to deliverability in this case.
Dealing with the fifth overarching point, which relates to alternatives. Matt Dygan gives weight, albeit limited weight, to the alternative employment sites which are proposed to be taken forward in the emerging local plan. The applicants are wrong to contend that no weight can be given to them as a matter of law, as appears to be the case, although we will hear from them in closing. First, we note that the proposed employment sites in the emerging local plan are as advanced as they can be short of public consultation. And Madam, I set out the work that's been done. So they were approved by the Planning and Transportation Working Group in August 2024. They were thereafter approved by the Policy and Resources Committee on the 11th of September. 3 sites were excluded, and those sites, as I explain in C, the remaining sites were yet further endorsed at full committee in December 2024. In cross-examination, it was suggested that Mr. Dygan's approach to employment land, where he gives weight to alternatives that may emerge, and housing, where he does not, was inconsistent. That point has no merit. The key distinction is the stage at which the alternatives are at, the employment sites being at a more advanced stage than the housing strategy. Indeed, Mr. Bashforth accepted that some weight could be given to the employment sites, although there is a difference between him and Mr. Dygan as to the extent of that weight. Mr. Bashforth was right to do so. If, as is agreed, the evidence base underpinning the emerging local plan is a material consideration, there is no reason why the employment sites which sit within that evidence base are not material. Second, it is not the case that alternatives may only be considered in exceptional circumstances. The relevant principles said to be well established are covered in the case of Stonehenge. Madam, there are a lot of cases in the footnote, but to be clear, they're all cases that are cited directly in Stonehenge itself. The principles for decision-making are as follows. Land may generally be developed in any way which is acceptable in planning terms. There is no fixed rule or one-size-fits-all rule on when alternatives may be considered. Those are quotations from the authorities. There is a spectrum. The greater the planning harm or departure from the local development plan, the more readily one might consider alternatives. In particular, it may well be relevant to consider whether there is a more appropriate site elsewhere, where the development is bound to have significant adverse effects, and where the major argument advanced in support of the application is that the need for the development outweighs the planning disadvantages. That comes from a case called Trust House Forte, cited in Stonehenge. The weight to be given to the alternatives is a matter of judgment for the decision maker in the planning balance. Continuing at paragraph 51, Lyle, Mainwaring and Carroll must be read as a whole. It reflects the authorities referred to above. It accepts that there is no one-size-fits-all rule on when alternatives may be considered. Alternatives are normally irrelevant where the application does not involve planning harm or conflict with planning policy. Alternatives were not relevant in that case, which involved simple householder applications consistent with the local development plan and with nothing out of the ordinary in planning policy terms. It can plainly be distinguished from a case like the present, not least where the policy itself contemplates the assessment of alternatives, like the National Landscape Policy in the framework. So, Madam, Swale's position on alternatives can be summarised as follows. There are alternative employment sites which can be given weight, albeit limited weight. That includes because of their democratic endorsement by full council. This case lies on the side of the spectrum that warrants considering alternatives. It is in many respects the classic example given above in Trust House Forte, and which I have previously read out. The case for considering the alternatives is all the more stronger given the indication in the KDNL policy, so the MPPF, that alternatives should be considered, or at least are a relevant consideration. In addition, the alternatives are on the evidence timed to come forward within the same period as the expansion of the KSP is proposed in the Southern Scheme, and thus the need for employment sites could be met in a way that may not harm the Kent Downs national landscape. They demonstrate a prospect of meeting the need upon which the applicants rely at lesser planning harm.
The section on alternatives, they're just talking about employment sites here, aren't you?
Madam, that's absolutely correct. We do not rely on the prospect of alternatives for housing, and I hope that was made clear in the paragraph 48.
Okay, yes, thank you.
And this is tied together in the planning balance at the end.
Thank you. There's then a short section 6 on the principle, the combined schemes and the LDP. And I'm not going to read all the paragraphs. I will start at paragraph 57, just because it sets out what we say about AS1. So we accept delivery of a Northern Relief Road has a policy basis in the plan. That, in truth, is the closest one gets to any principle.
Sorry, where are you now?
I'm at 57, sorry.
Okay.
Yeah, I'll start again. The delivery of a Northern Relief Road we accept has a policy basis in the plan. That is, in truth, the closest one gets to any principle for the combined schemes in the plan. The road project is recognised in policy ST53. Land is specifically safeguarded for it, but the principle recognised by policy should not be overstated. AS1 is an area of search and doesn't determine its route. That's point A. And B, it's the road and the road alone which is given the degree of policy support. Obviously, the combined schemes greatly exceed that. I'm going to go on to paragraph 58. Second, by contrast, the focal benefit of the Southern scheme, which is the Southern Relief Road that runs through it, has no basis in development plan policy. At best, the explanatory notes recognise the possibility of it coming forward in the future. This is significant given that it drives the harms to planning assets which the Secretary of State has singled out as deserving the highest of protection. And third, probably only 1/3 needed, the limited policy support that does exist for the delivery of a road in the Northern scheme does not reduce the harms from the road infrastructure, which KCC as Highways Authority has not understandably considered. And any benefits or policy counterweight, we say, applies in the planning balance and not before. In other words, you've still got to weigh the harms. Ultimately, there's no real imprimatur of policy principle that the combined schemes as a whole carry through to the planning balance. They are agreed to be contrary to the development plan, and the gossamer thread of AS1 clothes them with no real principle. Oh, I'm carrying on now. Main considerations not disputed by the Council. So we identify the main considerations not disputed. I'm going to speak to this and read bits of it, but I'll guide you and listeners at home through it. So none of the matters below are put forward for reasons for refusal. For many, there's a broad scope of agreement. The fact they're not reasons for refusal doesn't obviate the need to consider them, of course, when considering the harm occasioned by the schemes and conducting the planning balance. So, design, first of all, we've summarised some points there, casting our minds back at 63 to the very first day of the inquiry when we heard about the terroir of the site and the synergy of spaces and so on. And we leave it to you, paragraph 64, to decide whether the applicant's witnesses have overindulged somewhat in their commendation for the scheme. The fact of the matter remains that the road infrastructure remains at the core of this proposal, and as Ms. Brockhurst put it, the locationally specific need for the Southern Relief Road is the starting point for the applicant's exploration of the creation of new homes and places within the borough. It is the unifying feature, the driving force around which the necklace of villages is thread. And we make the point that despite, this is paragraph 65 and over, despite the various explanations of the way the scheme's been designed, and they say fundamentally redesigned to be a landscape-led scheme in May 2021, one might think, therefore, that the scheme would look very different from its earlier iterations, but it does not. And we can see back in 2006, what was being proposed was a very similar arrangement of homes, road, and spaces there. That's from the 2006 KSP application in Mr. Sutherland's evidence. So we say some things at paragraph 67 about the role of the road in fixing some of the parameters of the planning and the location of the junction. And then at 68, I will read this. The Council's position on design can be summarised as follows. To a large degree, the debate's an arid one. The applicants rightly place no weight on design in the planning balance. That's Mr. Bashforth's proof. Mr. Heifer explained for the Duchy it's difficult at this stage to make a judgment about how Highsted might turn out. And there's a more fundamental point. The Secretary of State positively expects development to be high quality, beautiful, sustainable. It's fundamental to what planning should do. Mr. Sutherland accepted in cross-examination that he wasn't saying the schemes overperform against policy, only that it meets planning objectives of these parts of the framework. Much of the master planning evidence, unsurprisingly, relied upon evidence put forward by others, landscape, heritage, ecology. The success or otherwise of the scheme can be tested in the usual way through those disciplines. We've said a few things about landscape led at paragraph 69. What does it really mean and does it matter? I'm not going to read that. Matter D, because these are the undisputed matters, effect of the proposals on the strategic and local highway network, as Mr. Daigen confirmed absolutely rightly in his evidence. The council had given over the highways points to National Highways and Kent County Council. We know that there's a statement of common ground that's been reached, and he endorsed those matters that were in the statement of common ground. But it's important, paragraph 71, to recognise that other matters that are the consequences of the highway infrastructure do fall within the council's remit. They include the non-highway benefits of the road, the economic benefits, its direct physical harm, its indirect harm from attendant traffic noise, loss of tranquility, and so on. Matter C, sustainable transport solutions. Again, nothing there objected to. I'm not going to read that. Matter E, noise and air quality. Again, there's common ground that's been reached on both of those things. We do make some, as Mr. Daigen did in his evidence, some comments about the extent to which it might be said there are benefits as opposed to just no objections. You'll remember Mr. Daigen's evidence on air quality. Paragraph 77, as far as noise is concerned, it's absolutely correct that there's no noise amenity objection in terms of residential amenity and so on. But we do, and you'll remember this from the landscape evidence, we do draw attention to the changes in tranquility of the area and say that those are relevant to that evidence. And just going over the page to page 30, you'll see that we've extracted a plan from the applicant's environmental statement that just graphically illustrates the changes in noise environment before and after. Matter H, which is the public highway network, we have deferred to KCC on those public rights of way. Yes, that's what I said. Oh, did I? I'm sorry. I meant to say public rights of way, and it's only 25 to 11. I meant to say public rights of way. We've deferred to Kent on that matter. Of course, those things are relevant to the extent of landscape change, and you'll remember Mr. Young cross-examined on that, and we picked that up again in the landscape section of the closing. Historic environment, this part of it is just dealing with below-ground archaeological resources. Again, we defer to Kent, and there's an agreement reached on that. So we then turn to the main considerations in issue, and we start with landscape. So I'm going to try not to read all of this section. It's quite long, which is reflecting the importance of the point and the length of the evidence that you've heard, but I'll dip into bits and speak to other bits, okay? I will start reading from 81. Protection of landscapes is a well-established feature of the framework. At a high level, development should generally be sympathetic to landscape setting, under the aegis of conserving and enhancing the natural environment in Chapter 16. the Secretary of State expects development to recognise the intrinsic character and beauty of the countryside. The framework recognises a hierarchy of environmental resources, including landscape, and we set out there the references to the national landscape, which of course are central to part of this case. 83. Landscape protection likewise permeates the local development plan. And again, we set out there some of the policies, in particular DM 24 referred to. And then at paragraph 84, we refer to the KDNL management plan, which is a statutory document prepared by the KDNL unit under the Countryside and Rights of Way Act. And we also flag up that it's referred to in policy DM 24 of the plan. That's paragraph 84. F2 over the page, paragraph 85, agreement and disagreement. The agreement and disagreement between the parties is set out in the Statement of Common Ground. There are some significant points of agreement. I'll go quite light over some of these. So first, agreed harm. There's a legion of agreed harm as a result of the schemes that needs to be carried forward into the planning balance. Secondly, plausible judgments. Ms Brockhurst accepted in cross-examination that all of Ms Ahern's judgments on the extent of harm from the schemes is plausible, and indeed that she'd been very fair in her assessment. While it's easy to overlook, given the lengths to which Ms Ahern was cross-examined, her judgments are, it's accepted by the applicant's own expert witnesses, ones which it's agreed are, this is the definition of plausible, seemingly likely to be true or able to be believed. Those are fair concessions because obviously this is a very judgmental area. Third, significant versus non-significant harm. The need to shoehorn harm into a significant box or a non-significant box is a particularity of the EIA process. It shouldn't detract from the need to understand truly what the harm is. And this is particularly important given that the Northern Scheme LVIA and the Southern Scheme LVIA adopt different gradings. As a perhaps surprising result, despite the fact that the Northern Scheme is much smaller in area and quantum of proposed development, and in a much less sensitive area, the Northern ES identifies more residual significant effects than the Southern ES. That's an illustration, really, of what emerges from these kinds of constrained processes where judgments need to be made in this way. When one stands back, that might seem like an odd outcome, but there we are. 89. Furthermore, the Southern Scheme LVIA has a particularly fine grading system. We raised this in cross-examination. It's worth reminding yourself of. The distinction between significant and not significant turns finally on whether that harm is moderate stroke substantial or simply moderate. And both of those categories have the same written description. Thus, on the Southern Scheme LVIA, two people could describe the same effect with the same words but legitimately reach opposing views on the important question of whether they're substantial. And we say, as was put in cross-examination, that's a serious weakness in the assessment methodology, and we've set out the relevant bit there in the table. You might remember that if you can cast your mind all the way back to the cross-examination, that the description of moderate substantial or moderate adverse, you'll see is there in the second extracted paragraph from under that table. And that in turn affects whether impacts are judged to be significant or not. Paragraph 91, overall approach. The evidence of Miss Ahern and Miss Brockhurst might be seen as ships passing each other in the night. Miss Ahern considers in granular detail harms from the scheme on landscape and visual terms and why they have been underestimated in the applicant's LVIA. By contrast, Miss Brockenhurst does not even refer to harm at all and deploys an impressive thesaurus of euphemisms instead. She rarely, if at all, condescends to discuss the detail of that harm. And proceeds on the basis that there will be significant adverse impacts from the schemes. Her proof overall makes the overarching submission that the schemes should be seen as part of an inevitable process of change in order to deliver necessary housing. This beguiling thesis breaks down into the following building blocks. Landscape is what it is, a dynamic relationship between people and place. The delivery of housing will bring change to the landscape, but change does not mean harmful, and the role of landscape assessment is not to prevent change, but to guide it in a way that contributes to the evolving character of the landscape. And then finally, the landscape impacts must be seen in the light of the landscape benefits, which will be delivered over the 100+ year timescales of the scheme. This approach is not accepted. Put simply, the appeal of any development, however great, cannot be a reason to look away from the extent and depth of the change, or to let it pass without attributing full weight to the obvious detrimental impacts it will bring. Indeed, as starkly as it is put in Miss Brockenhurst's proof of evidence, the approach presents obvious conflicts with the EIA process, whose role, as above, is not only to reach a view on the significant environmental effects of the development on land, and then integrate those conclusions into the decision whether to grant consent or not. It also sits unwell with the role of landscape assessment considered in Glivia, which, as Ms. Ahern explained in chief, seeks to give a clear understanding of what landscape is there, what will be lost, and what will change. The existence of benefits does not obviate the need to carefully consider the landscape harm as judged against the baseline identified in the landscape and visual impact assessment. It's telling that Miss Brockenhurst, if not rowing back...
I'm so sorry to interrupt. It is, and it comes up a lot, it's Mrs. Brockhurst rather
Brockhurst,
than
I thought that...
So I'll take responsibility.
Don't worry at all. I think it, but just remembering, it comes up quite a few. Obviously,
Yeah.
she's a witness who said a lot, so it comes up a lot. So just to remember when it's Mrs. Brockhurst, exactly so.
No need for sword falling, but I was saying Brockhurst and then I started reading Brockenhurst. So I imagine that she's listening, and in which yes, in which case our sincere apologies.
Awesome.
And yes, very sorry. We will get it right from now on. It's telling that Mrs. Brockhurst, if not rowing back, then significantly qualified her approach in oral evidence. The following concessions were rightly made and reflect the orthodox approach in Glivia 3. The harm to the landscape, as judged from the existing baseline, can't be meshed together with or reduced on account of the ultimate landscape benefits of the scheme. They are distinct. In the words of Glivia, notes they're independent of each other, and Mrs. Brockhurst accepted that in drawing attention to the landscape benefits of the scheme, she's simply informing the benefits that go to the planning balance undertaken by others. The different landscape characters or benefits created from the development and landscaping plan cannot be judged as mitigation to reduce or mask, as she said, the impacts from the change to the landscape. And the assessment of landscape impact should not look at a hypothetical situation in 100 years' time. That's not what is measured in the LVIA, which focuses on change against an existing baseline. The applicants in cross-examination often charge Miss Ahern with failing to recognise the benefits of the scheme. That's not a fair representation of her evidence. She expressly accepted that some parts of landscape change can, of course, be beneficial. She's openly accepted the benefits of the scheme as they relate to her field of expertise, but as she rightly noted, very few of the viewpoints assessed in the LVIA suggested any such beneficial change. Thus, for example, her assessment of harm almost always reduces to take account of mitigation planting. She recognises, for example, the beneficial effects of the southern site on biodiversity and woodlands. Her approach, we say, is fair and accurate reflection of the extent of landscape harm when compared against the existing baseline. There was a debate about the size of landscape area impacted, and much of Mrs. Brockhurst's evidence often sought to diminish the landscape harm because, it is said, only a part of the overall landscape is affected. To be clear, on its own merits, this is not always correct, given, for example, the large scale of the AHLV which is impacted, but it's conceptually flawed, we say. As Miss Miller explained in chief, it would be a strange notion to consider that in order for an impact to be harmful, it would have to occupy a whole area at that scale. There's nothing in the framework that suggests landscape harm ought to be discounted where it's below a certain size, and the Glivia notes, while accepting the geographical extent of harm is relevant, expressly cautions against understating the resulting magnitude of impact on this account. That's unsurprising. Landscapes are designated as a whole. The loss of part of them, even in small part, can impact the qualities of the whole. One should not overlook death by 1,000 cuts, not least in an area like the national landscape, which precisely suffers from extreme development pressures and whose qualities are liable to erosion through incremental, cumulative development over time. There was also a point about trends in change. The concept of trends in change is lifted from a single paragraph in Glivia. Its role should not be overstated. This again is an EIA context in which significant harms are identified in the baseline and they need to be fully considered and integrated into the decision. The Glivia notes are clear that the Glivia assessment process and judgments operate independently of policy, and of course the landscape benefits, such as they are, will need to be weighed in the planning balance. But the harms are not diminished or tempered by those benefits or planning policy. The line taken in cross-examination, you may or may not be able to cast your mind back to this, but it was a point made that Miss Ahern hadn't taken the right baseline because of changes that would be allegedly supported by policy in the plan. It's to do with the road. The line taken in cross-examination suggested Miss Ahern had committed a cardinal professional sin in not considering this literally trendy concept. This is a curious position to take. Mrs. Brockhurst proof makes an isolated reference to the concept in respect of a single trend, which is the delivery of the Northern Relief Road. And as elsewhere, Mrs. Brockhurst rode back significantly from this in cross-examination when she was asked about the baseline of the Northern Relief Road, and we set it out in full given its importance to the assessment. She accepted that under Glivia, one assesses landscape harm by reference to the baseline. She confirmed she was not suggesting the Northern Relief Road should be treated as part of the baseline. That's really the critical point. She then accepted that the trends in change, so to speak, don't inform the landscape and visual impact assessment, but come into play in the planning balance. A matter for Mr. Bashforth, of course, and not her. And after cross-examination, the following was agreed and reflects a conventional, reliable approach. The baseline is as is, based on its characteristics and sensitivity to change. You need to reach a reasoned conclusion on the landscape effects of the proposal and in both construction and year 1 and 15, and then in the planning balance integrate that conclusion on the landscape impacts and the overall assessment of the scheme. Nothing original there. We then say something about the northern scheme, and I do want to draw your attention to footnote 103 because you might remember, again, all the way back, when I started my cross-examination, I said I would cross-examine on the northern scheme, and there was cross-examination on general points that wash over both north and south. But I didn't actually expressly cross-examine on the northern scheme, and I've explained why at footnote 103. And as a consequence of that, but it was a decision made at the time, in our closing, we have really done no more than set out the dispute as it is on the basis of the written evidence, and then those concessions that were gained in cross-examination that wash over both north and south. And we do also refer to Mr. Young's cross-examination that related to the sensitivity of rights of way in the northern assessment. So I hope that's a fair way of doing it, but I thought it was worth explaining in case that in case it needed it. So the northern scheme and its impacts. I'm going to speak to some of this and read some of it. So you'll see that on page 39 we have extracted plans that show some of the landscape areas and landscape sensitivity assessment. We've also then on page 40 extracted some plans that show some of the key areas for rural lanes and the rights of way. We've mentioned at paragraph 103 the safeguarding the area of search for the Northern Relief Road. Paragraphs 105 onwards, refer to matters of agreed harm. We then come on to disputed harm, and we've got 6 points, and I'll part read and part speak to these if I might. So this is on page 42, and it's starting from 109. We make 6 observations on the evidence. First, we say, at a high level, the effects of the Northern Scheme have been underestimated on 3 broad counts. The first relates to the sensitivity of public rights of way users, and we pray and aid Mr. Young's cross-examination of Mrs. Brockhurst here, where it was accepted that those receptors should be treated as of the highest sensitivity, whereas many of them, as we say at A, were assessed as being of low sensitivity. That's the first point A. Secondly, the magnitude of impact from construction and operation of the Northern Relief Road. The Relief Road cuts across the historic grain of roads and tracks between Batchild and Tong Mill, dissecting fields, orchards and the Tong Conservation Area and compromising the tranquil character of the area. The environmental statement says in somewhat clinical terms it would be likely to diminish the user experience of the rights of way. This impact's been classically underestimated, we say, and not been faithfully reflected in the applicant's assessment of harm from the scheme. And then in C, the applicant accepts there would be moderate adverse impacts on the landscape pattern, land use, land cover and management. And again, we say that that's this is in Miss Ahern's evidence, an underestimation. 111, I'm just going to take a sip of water. We set out there reasons why Miss Ahern's assessment of the moderate adverse impacts on the western part of the site are to be preferred. I'm not going to read those out. We make some criticisms in the indented points of the applicant's assessment. 112, visual impacts. Visual impacts which would have at least major adverse impacts are chiefly agreed, although Miss Ahern considers there'd be greater impacts. The remaining areas of disagreement centre on the impacts on the rights of way, and that then links back to the sensitivity of the rights of way as receptors. We also say, this is 113, that the magnitude has been underestimated, and we give some examples there, again, based upon Miss Ahern's evidence. Paragraph 114, we refer to the impact on rural lanes, particularly Hempstead Lane. Paragraph 115, we say this: the short point is that on the Northern Scheme, it's agreed that all rural lanes will suffer a minor adverse effect, save in respect of Hempstead Lane, which Miss Ahern explains will experience a moderate adverse effect. And we say why we think her view is to be preferred. 116, we make some brief observations on the remaining aspects of the landscape evidence. There's a point about hedgerows, a point about the Tong Country Park, and we then come on at 117 to the 6th point, which is about mitigation. We accept would soften the overall character as it matures. But one needs to see that with realism, and we refer to the urbanising effects of the development, notwithstanding the mitigation. And at 118, we simply draw attention just to the limits of mitigation. For example, for the Northern Relief Road, there are certainly certain impacts which can't sensibly, we say, be mitigated against because of their magnitude and nature, and we draw attention to one there, which is the effect of the Northern Relief Road in dividing the conservation area. So that's the Northern Scheme. I wonder if now might be a time to have a break, not least because I can feel my voice needing a rest, if that's okay.
That's fine, thank you. Shall we have a we'll have our usual break, I think, for 20 minutes. All right, so we will adjourn till 11:20.
Just to say we'll be.
You'll be going.
At this point
Oh, will you?
without any discussion.
Well, I'll just break the fourth wall and just apologize. I was thinking, why have I referred to Brockenhurst? And then I realized, I Googled it. My parents lived in Brockenhurst for a while, and I think it just subconsciously came through. So very much Freudian rather than
Well,
any intention to
it's-
disrespect to Mrs. Brockhurst.
She's confirmed that apologies accepted. So we're
Right, thank you very much. It is now 11:20, so it's time for the inquiry to resume. And I think we were on page 47. weren't
We were, and which also means that we're making good progress,
Are
actually.
we? Oh, good.
Yes.
Right.
Yes.
Oh, yes, perhaps we are.
So, next, the southern scheme and its impacts. The scale and nature of impacts is far greater than the northern scheme, obviously. On any sensible view, the southern scheme obviously and permanently harms two of the highest landscape policy designations, namely the Kent Downs National Landscape and the area of high landscape value. In addition, in contrast to the northern relief road, the southern relief road has no policy support in the local development plan. As far as the local development plan is concerned, there's no counterweight of policy support for the principle of the road, which contributes in large part to the harm from the southern scheme. We address the impacts in the following order from south to north. So we start with the national landscape, then the area of high landscape value, then other landscape impacts. So the Kent Downs National Landscape. Mr. Stevens, the self-effacing butler in The Remains of the Day, mused that the English landscape at its finest possesses a quality that the landscape of other nations, however more superficially dramatic, inevitably fails to possess. That quality, he thought, was greatness, not a greatness that needs to be shouted about, but an innate and self-assured greatness. The Kent Downs National Landscape plainly has that quality. It provides an expansive panoramic vista which spans and defines the landscape, crisscrossed by dry valleys and narrow sunken lanes. It marries broad arable fields stretching across the chalk plateau with scattered belts of trees holding them in check. But its scenery alone does not capture its true value. Millennia of human activity have created an outstanding cultural dimension to the landscape, borne witness to in its scattered farms, flint-built churches and isolated agrarian settlements, which give it a profound sense of time depth. And it has in turn inspired great artists, Charles Dickens and Samuel Palmer, social thinkers, the National Trust, and national icons such as Winston Churchill. It is precisely why national policy and legislation confers upon such landscapes the highest level of protection. But it is under threat from suburbanisation and edge degradation, from infrastructure intrusion, from landscape fragmentation, and from the loss of traditional land use patterns. It experiences severe development pressure from unprecedented growth. Of particular concern is cumulative change with multiple developments, each disclaiming an impact on the national landscape coming forward, progressively diminishing the qualities of the character of the national landscape, the antithesis of sustainable development. This doesn't mean that any development must be prohibited, but it does mean that any such development must be carefully scrutinised, particularly where it is claimed that it will not contribute to those underlying threats. The stringent planning policies guarding against those threats must be applied faithfully, and the harm to the special qualities appropriately compensated for where possible, so that other areas of the landscape can be improved. It's noteworthy that the Council isn't alone in its objection. The harm to the natural qualities of the historical qualities of the landscape have given rise to objections from Natural England and Historic England, consultees whose views should be accorded significant weight. To orientate ourselves, the 14-hectare area of the national landscape given over to infrastructure lies within the Bicknor local character area. It sits more broadly within the 1B Mid-Kent Downs landscape character area, itself within the Chalk Downs landscape character type. We address the impacts as follows, noting that the protected landscape duty is addressed in paragraph 412 in the section 106 obligations section. So we deal with direct, then indirect impacts, then impacts on the setting. So direct impacts. This considers the impacts of the 14 hectares of the southern scheme in the national landscape. In a testament to the overlapping richness of the national landscape, many of the harms spill over from one quality to the other. Currently, Ms. Miller describes the national landscape site as making a positive contribution to the national landscape and sharing much of its core characteristics. The chief source of harm to the national landscape site is, of course, the highways infrastructure. We've more detail on the M2 junction than for the rest of the infrastructure and it's realistic, we're told, to work on the basis of the feasibility of the conceptual designs that are in that core document. We summarise the features of this three-way, two-level trumpet interchange, which is proposed. First, it's bulky. The westbound exit loop will have a radius of 75 metres. It will be at least 19.3 metres wide, although that's an underestimate. It will be elevated. As the M2 sits in a cutting at 85 metres AOD, the bridge parapet on the westbound loop will have to stretch 9 metres higher to gain the necessary height to clear the M2. The road itself will be at 7 metres, that's 92 metres AOD. Adding to that bulk, the height gain will allow the loop to cross the M2 will require substantial earthworks. Immediately south of the overbridge, the works will sit about 5 metres above existing ground levels. To the north, the eastbound slip road will also have to rise to meet the northern part of the M2 overbridge, which will require a significant additional landmass. These are all in the CD, that's CD 34.11.3 that's flagged at the start of the list. The traffic will have a clear adverse experiential impacts. It will be fast. Most connector roads are at 85 kilometres per hour, and there'll be a lot of it. It's predicted to have over 2,000 peak flow movements in the morning and 3,000 in the afternoon. And there will also be road infrastructure clutter. No full design of these elements has been considered, but the road will inevitably include a vehicle restraint system, that's a fancy way of saying crash barrier, and will most likely include signage. No lighting design has been prepared, but it is assumed that the junction will be lit. The junction plainly would constitute a major incursion and fundamentally alter the KDNL site from its current rural and undeveloped character. Miss Miller's evidence. The suggestion the M2 detracts from the KDNL is a recurring theme in the applicant's evidence. The council's position is that this is overstated, although no doubt you will have made your own impression from your site visits. The M2 is in a cutting which reduces the noise and visual appreciation of the motorway. The motorway is also on land appreciably lower than the National Landscape site, and the traffic is separated from views by a line of trees. The overall impression in this location, supported by the landscape studies, is of an area with a rural and peaceful feel despite the proximity to the M2. The principal residual effects on the national landscape, noting the agreed major substantial adverse construction impacts, are in summary: A, dramatic landform and views, significant negative. Scenery and views are by far the most highly valued feature of the landscape, national landscape, so this proposal strikes at what is most valued in that landscape. The National Landscape site shares much of what makes those dramatic views special. It lies in a plateau on relatively high ground between two dry valleys. It flows directly into the Highsted Valley and is read as part of that dramatic landform. The major highways infrastructure will disrupt the current flat nature of the site and legibility as plateau land, not least given the significant height of the junction. Some insight into the scale and nature of what is proposed and its impact can be gleaned from VISO 5, showing the view from Bexon Lane and Ruins Barn Road. It remains the only visualisation of the new junction within the landscape, and notably the LVIA assessed significant effects in nearby views over the new junction from Bexon Lane. Miss Miller's view is that this is transformative change in the view, and it's difficult to resist that conclusion. The farmed landscape. The National Landscape site is, like most of Bicknor, arable farmland and woodland. The proposal will remove 14 hectares of land from agricultural production, all of which is BMVL, and replace it with highways infrastructure, resulting in a significant adverse effect on the farm landscape. In the case that the tree, it is the case that the tree break division between the west and eastern fields will be retained, but the shelter belt will no longer enclose arable fields, and as such they'll be robbed of a key characteristic of the area: tranquility. Tranquility is singled out for particular protection in the local development plan as valuable resources once lost, which is difficult to regain. The development will significantly impact the tranquility of the KDNL through construction noise, increased vehicular activity, including from high-sided, bright-coloured HGVs, lighting, leading to a significant negative effect on this special quality. Bicknor generally has a strongly rural and peaceful feel despite its proximity to urban areas. Whilst the M2 is physically close, its impact is not readily perceived given the factors discussed above. The addition of vehicular movement and associated clutter by the development will have a pronounced effect on tranquility. Finally, there's no light source within the National Landscape site at all, and the site is particularly sensitive to the introduction of new lighting. Such lighting is all but inevitable given the lighting requirements of road infrastructure, but, if not, the headlights of vehicles on the road. Historic and cultural heritage impacts. The national landscape is very much a cultural landscape formed by thousands of years of human activity. The rural, scattered farmsteads bear testimony to its agricultural history. It is in these gentle hamlets that we see the traces of ordinary people who have worked the land for centuries and shaped its special character. The introduction of the motorway junction will negatively impact this sense of timelessness. Within the National Landscape site itself, the development would reduce the legibility of its historic landscape features, the old chalk pit and Duke Shaw, by subsuming them within the proposed replacement tree planting. More broadly, it will particularly affect the setting of the historic settlement of Bexon by eroding its agrarian context, in particularly the highly graded Bexon Court. The dark sky impact of the development will be more keenly felt given that Bexon and Bredgar currently have no street lighting. Bexon would no longer be read as a good example of one of the dispersed farmsteads and modest hamlets which Historic England explained characterise this area. And finally, geology and natural resources, albeit minor, negative overall. This overlaps with the loss of the agricultural land, and in addition, the proposal will impact the underlying chalk geology and soils due to extensive earthworks and potential piling operations. As for the mitigation, it is recognised that the tree planting could screen some of the development, but it does nothing to address the existing features of the National Landscape site which are lost, nor harmful features that are inherent to the development like noise and traffic. Mitigating that further, such as through barriers, would accentuate the visual and other harm and accentuate the loss of rural fields. Now to indirect impacts. The scheme would add roughly 17,000 new residents in the southern site. It's worth just pondering that number. Indirect impacts on the national landscape are, broadly speaking, threefold: recreational pressure, urban fringe influences, and increased use of the rural lane network. There's no dispute the southern scheme will result in more visitors to the national landscape. As Miss Miller rightly emphasised in her written and oral evidence, access to the national landscape is not a problem, it's to be celebrated, but it must be carefully managed. The national landscape, unsurprisingly given its beauty, has 20 million visitors a year, roughly the same as the Cotswold National Landscape, which is twice its size. The problems with unchecked or unmanaged visitation are clear and directly undermine the special qualities of the national landscape. And indeed, the national landscape loses its accessibility when access is not carefully managed. Its walking paths become over-visited, its parking facilities become often overwhelmed at weekends, and antisocial behaviour such as fly tipping or inappropriate recreational access increases. The national landscape in the vicinity of the site has particular recreational appeal. It provides the characteristic and dramatic long views over the Swale, a network of public rights of way, ancient woodland, Minching Wood. The consequences of irresponsible recreational pressure are well documented in Miss Miller's proof, as are the more pernicious examples of outright criminal activity like fly tipping. Whilst it is possible that the Southern Relief Road results in some reduction in rat running on roads through the national landscape, this does need to be approached with some care. The applicants candidly accept the modelling simplifies the rural lanes around the M2 and caution that care should be taken not to draw absolute conclusions of traffic in the context of the network, particularly in the national landscape. Seen as a whole, the development plainly does result in the serious potential for harm to the national landscape through recreational pressure and urbanising influences, as Miss Miller has explained. The Council's position is that the above indirect harm can, in principle, be mitigated if, but only if, adequate measures are put in place to do so. However, these plainly require long-term investment. Indeed, short-term investments which achieve benefits but then drop away are of themselves harmful to the visitors who come to enjoy the new access but then are disappointed when it's not maintained. The management plan makes the point well. We quote, "Investments need to be long-term. It can be more damaging to have short-run projects that achieve some benefit then drop away. This is as true for farmers and land managers as it is for those experiencing new access." Compensation is addressed further in the section dealing with compensation. That's in the section 106 part. The short point is that the applications would contribute to the unprecedented growth and development pressures which the national landscape seeks to guard against and to which effective measures must be directed. Setting impacts. The setting of a national landscape is firmly rooted in policy and practice, which recognises that setting often makes an important contribution to a national landscape, and development within it can do significant harm. It is the land outside the designated area which is visible from the national landscape and from which the national landscape can be seen. That's what the setting is. Whilst it has no formal designation or indication on a map, the parties are broadly agreed that the Highsted part of the southern site is within the setting of the national landscape. The setting of the national landscape with its dry chalk valleys frames the dramatic views for which it is rightly valued. The views out of the landscape over that setting were a, quotes, key reason for designation in 1968, critical to its value and central to the reasons why people appreciate it so much. The value of the setting is recognised in the AHLV, which washes over much of the southern site and which the applicants agree is similar to the landscape of the national landscape and intervisible with it. Mrs. Brockhurst underplays the extent of setting harm by contending the M2 serves as a dividing partition or abrupt demarcation between the national landscape and the southern site, and we don't accept this. The partition along the M2 was born of administrative convenience when the national landscape was designated. It does not reflect the landscape boundary in terms of the appreciation of the landscape. As is apparent on site, the setting and the national landscape form an essentially continuous landscape with dry chalk valleys running through toward the scarp of the national landscape. Her view, respectfully, is in marked contrast to the available sources, which clearly recognise the symbiosis and not separation between the area of high landscape value and the national landscape. See further, para 150 below. The harm to the setting of the national landscape, which overlaps with the harm to the AHLV, can be divided into three, and I'll speak more to this than read it out. Paragraph 145, impact on views and landscape character. We make some reference to the environmental statement there and the urbanising environment. Paragraph 146, we refer to building heights and the employment buildings. So that's impact on views and landscape character. 147, landscape and tranquility. As put in the setting statement, loss of tranquility through the introduction or increase of lighting, noise or traffic movement or other environmental impact, including dust, vibration and reduction in air quality. We contrast there the applicant's recognition of the absence of light sources in the setting with the effects that the development will have. We make some comments about the existing science park in the setting, which we plainly recognise, and then mention the sports pitches that are proposed. 148, impact on the recreational experience, and we there refer to the public rights of way network and what Miss Miller referred to as the gateway or transition zone into the national landscape, which is part of the function of the setting. So with that then, I'll pass on to the area of high landscape value. 149. The AHLV's characteristics can be summarised as follows. Distinctive dry chalk valleys that extend north of the KDNL, enclosed by steep slopes rising to open arable fields. Narrow sunken rural lanes, which are a traditional feature, adding historical and aesthetic value. That adds further context to the landscape and other harm to the rural lanes, as they are a constituent aspect of what makes the AHLV special, and panoramic and linear views, often from the extensive network of public rights-of-way which crisscross the site and which are crucial for appreciating the rural landscape's beauty and tranquility. The harm to the AHLV aligns to a considerable degree with the harm to the KDNL setting. Indeed, that so many of the qualities of the AHLV match those of the KDNL make it difficult to accept the applicant's case that the M2 acts as a barrier. That's a point we've touched on already. 151. Even on a quantitative approach, which isn't accepted as a matter of principle to be conclusive of the matter, 44% of the AHLV entire area would be given over to the development. Over a quarter of that land take would be for built development, principally housing estates. That's quite a staggering change. And qualitatively, the impacts would be severe. The Southern Relief Road itself requiring significant tracts of land to be raised and altered. It would itself require a large junction at Highsted Road, Stockers Hill, which would cut across the AHLV's defining dry valley, at times up to 5 metres above the landmass. And the mitigation planting would itself accentuate the unusual linear pattern of development and associated mitigation planting along the main corridor. Mr. Hearn's oral evidence description of the Southern Relief Road as charging through the AHLV and severing small parts of ancient woodland, which are its hallmarks, that's to say, the hallmarks of the AHLV, is a fair one, and points to the depredation visited upon this valued landscape by the Southern scheme. Mrs. Brockhurst rightly conceded in cross-examination that the description of the AHLV would have to be rewritten if the Southern scheme were granted planning permission. It is in truth, we say, difficult to see why the AHLV would merit designation as such when the schemes, if and when the schemes are built. We then mention the operational impacts, which would impact the strong sense of tranquility that's currently identified in the area despite its proximity to the urban area. 155. That much of the land take would be for green space strategy does not improve the situation. It would still replace the arable context of the AHLV with landscape of a fundamentally different kind, and even that green space would, when all is said and done, be articulated around a road, which the council say would form its dominant setting. Opportunities for successful mitigation are limited given the nature of the development, and we say its success has been clearly overestimated, and we give some examples there. And at 157, put simply, the proposals are fundamentally at odds with the aims of the area of high landscape value. That the ES discerns only, this again we say is quite a remarkable conclusion, slight adverse to negligible harm from the scheme on the area of high landscape value is baffling. I think that is the correct word to put there, baffling, and again lends credence to Mr. Hearn's view that the ES has overall systematically underestimated its impacts. Other impacts, we say there quite fairly, not to be forgotten, landscape's not just about the heavy hitters of the national landscape and the AHLV, but other landscape impacts as well, and we tie those up at 158 and 159. Conclusions on this topic. Obviously it feeds into the planning balance later, but for now on this topic. 160. The applications individually and together fail to live up to the expectations of the framework. They fail to safeguard what is special about Swale. The applicants have seriously underestimated the effect of giving over vast swathes of land, including land of the highest landscape quality, to urbanised forms of development. Their confidence in the mitigation measures is misplaced, not least as at this outline stage, when a worst-case reasonable scenario should be adopted. This trickles down into the proposal's compliance with the plan. The applications do not on that account comply with the settlement strategy, which seeks to release land outside the boundary only where it safeguards landscape setting, and we've referred to the policies there. Thank you.
Madam, I will continue with heritage assets. And Madam, for the reasons which will become apparent, I propose to speak to this chapter rather than read everything out. But I will read the introductory parts. Madam, there will be a harm to a plethora of listed heritage assets throughout the sites, which we considered below. The statutory duties imposed upon the Secretary of State are clear. That harm is not merely to be carefully considered in the balance, it must actually be given great weight. That harm can only be countenanced if there is clear and convincing justification for it. For non-listed assets, the framework requires a balanced judgment to be taken having regard to the direct or indirect harm to that asset. Madam, in paragraph 164, I tie in that those statutory duties and the framework to the local development plan. At paragraph 165, I explain how the topic is considered. So we consider common ground and difference between the parties, which, as I've explained, I'll read out. We then consider the northern scheme broken down into 4 classes of assets. And finally, we consider the southern scheme. And we take some assets from the northern part of the southern scheme, the central part of the southern scheme, and the southern part of the southern scheme. Common ground and difference. At paragraph 166, Madam, I go through the statement of common ground and I set out the number of assets for which there is no harm in A, agreed harm in B, noting that that includes a medium level of less than substantial harm to the highly graded church of St Nicholas in Rodmersham, which is at grade 1, and then I set out the assets for which the harm is not agreed. Continuing at paragraph 167, with the exception of Tong Conservation Area, which is directly harmed by the Northern Relief Road, Madam, I note that the harm is to the setting of the assets, i.e. to the surroundings in which it is experienced. And I go through the Historic England's setting note, which forms the agreed approach to setting harm, and I set out 3 principles that are of relevance. In subparagraph A, I explained that views to or from an asset will play an important part of an asset setting. In B, I explained that setting is not limited to visual matters. And in C, this one I'll read out the final line. It says, severing the last link between an asset and its original setting may be of particular relevance. At paragraph 168, I explain that the dispute in all cases, including Tong Conservation Area, is where the harm lies on the scale of less than substantial harm. This is not a feather in the combined scheme's cap. It means that the harm in question is that of 1,000 cuts to many assets and not a killer blow to a single one. Fourth, Dr. Mealy accepted that Mrs. Soane's approach is free of any error of law, policy, or approach. Indeed, in cross-examination, he accepted that all of Miss Soane's conclusions are plausible. The difference. In a nutshell, the dispute between the parties boils down to 2 interrelated issues. First, what role does setting, in particular the agrarian landscape, play in the appreciation of the heritage assets? And second, to what extent will the setting be harmed by the schemes? And we make 4 overall observations on the evidence. First, the experts. Miss Soanes has repeatedly found less harm than that reported in the applicant's environmental statement, on occasion much less. She did so well before Swale proposed to refuse planning permission. Her judgment has the hallmarks of a frank and independent expert assessment, which is commended to the Secretary of State. By contrast, Dr. Mealy not only departed from the harm as found in the environmental statement, prepared by his team, I add, but then shortly before the opening of inquiry resiled from a statement of common ground which he signed in January 2025. Each of the departures revised the extent of harm as he found it down. Second, neither policy nor associated guidance impose any glass ceiling on the level to which setting harm can travel, nor suggest that there should be any presumption or caution in assessing such harm as high. On the contrary, as is agreed between the parties, the assessment of harm to the setting of an asset is a matter of planning judgment, unconstrained by such presumptions, cautions, or artificial glass ceilings. When put to Dr. Mealy in cross-examination, he accepted that the calibration of his own judgment was such that the setting harm, by its very nature, was unlikely to go above medium. Continuing on at paragraph 173, he has in effect applied a glass ceiling unsupported by policy, guidance, or any other published material to which this inquiry has been referred. It is not surprising that he has not gone above that level, so medium, in this case, though others have, including his team members in the environmental statement and Historic England, a statutory consultee. Third, the dispute on setting. At a high level of abstraction, for Miss Soanes, the significance of the asset in large part derives from their relationship with the agricultural, agrarian and rural landscape that forms their setting. Where the parties differ, Dr. Mealy's assessment tends to downplay that relationship because, amongst other things, the landscape in question has changed over time. We offer 3 responses to this at a high level. First, the current agricultural context of the setting is the modern expression of a past connection, even if it is not identical to that original landscape. And that fundamental connection remains to this day and is important and often critical aspect of the setting. The loss of the field boundaries over time obviously corrodes the historical purity of the landscape, but it does not, we say, materially reduce the contribution of the rural agrarian landscape to how the asset is actually experienced today. Second, this retro focus on past change overlooks the need to consider whether the scheme better reveals the existing setting or what remains of it. Indeed, even if heritage assets have been compromised in the past, consideration still needs to be given to whether additional change will further detract from the significance of the asset. This is of particular importance here, given that in many cases the northern scheme would sever the last link between an asset and its agrarian setting. That this setting has undergone some degree of change and that past risks devaluing this severance. Third, at least part of the landscape change on which Dr. Mealy relies has been driven by change in agriculture. Small farms have given way to larger land holdings as agriculture mechanized in the 19th century and commercialized in the 20th. Orchards have been supplanted by hops or grain. But the change heralded by this development would be of a change of a fundamentally different kind, replacing agricultural use with a housing estate, for example. It cannot be seen as the logical extension of a process of change. For the same reason, these applications cannot sensibly be understood as put to Miss Soanes in cross-examination, as part of what Swale's Heritage Strategy and Action Plan recognises as interlocking change. The schemes in large part herald a step change by replacing large swathes of farming landscape with a housing estate. Fourth, the approach to harm. The nub of the harm is the extent to which the assets would be divorced or separated from their agrarian context, as I have explained. Contrary to what was put to Miss Soanes, there is no mathematical approach to assessing this. Medium, lower than substantial harm does not correlate, for example.
Less than substantial harm.
Did I not say
You said lower, didn't you?
less than?
Yeah.
Substantial harm. Yes, less than substantial harm. Medium, less than substantial harm does not correlate to 50% of the key aspects of an asset's significance being drained away. This is perhaps unsurprising. It is agreed that there is no formal best practice scale or terminology. If the mathematical approach urged upon Miss Soanes has any purchase, one would expect a standardized scientific method of assessment. The assessment of harm is a matter for professional judgment, not calipers. Relatedly, it was repeatedly put to Miss Soanes that a particular asset would still be worthy of designation if the scheme or schemes were granted planning permission, or other aspects of an asset, particularly its built form, would be preserved by that scheme or those schemes. These are, we say, misleading and unhelpful yardsticks for less than substantial harm or setting harm. Focusing on what remains tells us little about what is removed, and the lack of impacts on the built form tells us little about how that building would be appreciated when decontextualized from its wider setting. What matters is the impacts of the scheme on how the assets are appreciated, not on some hypothetical listing exercise. Now, madam, essentially that approach plays out for almost all of the assets that have been considered. So I'll read through some parts of the Tong Conservation Area, some parts of Frognal, and then I'll just talk through the rest in the interest of time. Continuing at paragraph 178, the special interest of Tong Conservation Area lies in the long continuity of settlement and milling activity from the 11th century onwards, shaped by the stream, spring, and mill pond that define its form and function. The area includes the earthworks of Tong Castle, associations with the cult of Thomas Becket, and rare surviving examples of Kentish vernacular industrial architecture. Visually, the area is characterised by a harmonious relationship between historic buildings, water features, and an open rural agrarian landscape with mature trees, open views across the mill pond, and narrow lanes that frame a series of evolving picturesque scenes. I go on there to describe that the impact of the northern relief road to the conservation area itself under the heading of direct harm at paragraph 180. At 181, Madam, I note that, and this is the second sentence, Dr. Mealy refers to the road as, and I quote, interrupting the continuity of the stream, which is historically important in communicating the historic purpose of the conservation area. It decouples the spring and its association with Thomas à Becket from the remains to the north, sapping the time depth which Dr. Mealy accepts is an important part of the conservation area's significance. And Madam, you may recall that in cross-examination, you identified that the key issue in relation to the Tong conservation area is the extent to which the stream contributes to the significance of the conservation area as a whole. And I go on to address that, paragraph 183. The stream, we say, tells the story of Tong. It provides one of the essential prerequisites for earlier habitation of the site. It then bears testament to the history of milling, stretching as far back as the Domesday Book to the 20th century, by feeding the watermills and then powering the stream mills when industrialisation took hold. Unsurprisingly, the Tong Conservation Area document recognises the significance of not only the stream and the mill pond in their own right, but their relationship to the castle and mills. The value of the stream, therefore, is relational. Historic England captures the point well. The road, it said, would truncate the southern limb of the conservation area from the mill complex to the north. It then says this would severely impact an appreciation of the historic functional relationship between the springhead, spring, and mill pond it fed. This further relationship between the stream and water meadow are essential to understand how a mill complex function. So we say the relationship of the stream to the conservation area is essential, and it brings the conservation area to life. And at paragraph 185, Madam, we note that the conservation area was recently revisited in 2021, and it plainly could have just been limited to the northern core of buildings in the north, but it wasn't. At paragraph 187, we address the implication of the stream not always being visible throughout the conservation area, but of course setting doesn't only depend on intervisibility. Madam, at paragraph 188, we address the setting impacts. At paragraph 189, we address the mitigation. And Madam, at paragraph 190, we bring together the various professional opinions that stand before you, as it were. As a sense check, Dr. Mealy's assessment is clearly an outlier. He is the only, and it says party, I should say expert, apologies. He is the only expert to this inquiry putting forward a medium harm. Dr. Doggett, Heritage England, a statutory consultee, and the applicant's own environmental assessment all consider the harm to be high. Ms. Soane's assessment, given the major impact on the open part of the conservation area of medium to high, is commended to you, Madam, and the Secretary of State. Madam, I then address Frognall Farmhouse.
Just sorry, before you carry on, you said it said in paragraph 177 that Dr. Mealy was high level of harm, and that Miss Soanes was medium to high. Got that wrong?
Madam, I can double check that. So you're asking, I'll double check and revert perhaps after the lunch break.
It doesn't seem to.
Sorry, Madam, where are you referring to? Paragraph 177?
177, you've got that little quote there.
Yeah.
Where it says Tong Conservation, Dr. Mealy is high, Miss Soanes is medium to high.
I see. It's possible that must be an error. Madam, can I just take that away and double check that? I suspect that it's just the wrong way round, but of course I want to double check and make sure that I'm not.
It doesn't, it's not consistent with paragraph 190 anyway.
Exactly, yes, and it would be unlikely that Dr. Mealy is finding higher harm than Miss Soanes.
It seems rather unlikely.
Yes, Madam, I apologise for that. I'll double check that.
Okay.
Madam, for Frognall Farmhouse, I will just read out paragraph 192, which explains the relationship between the setting and the significance of the asset. The symbiosis of built form of the agrarian landscape the symbiosis of built form and landscape is particularly pronounced for these assets. It plays out on 3 levels. The agricultural landscape wraps around these assets to the south, east, and west. Their visual relationship with this landscape is readily discernible, including, in particular, from open views within the listed building. The viewpoints are not just scenic, they reveal the farmstead's function and form by anchoring them within an agricultural landscape. There is also a functional relationship. The landscape which surrounds the assets is a functional agricultural workplace at present. The agricultural setting informs their understanding as a group of building with a clear agrarian connection. It puts the farm in Frognall Farmhouse. And finally, there is a historic context to the relationship between the broader agrarian landscape and the assets, which the tithe maps of around 1840 show as part of a larger agricultural unit. While some tithes have been lost, the owners of Frognall Farmhouse no longer own that part of the landscape. The sense of time depth, we say, persists. We go on to consider various other matters, and at paragraph 195 we note that Dr. Mealy accepted that the last connection to this asset's wider agrarian landscape would be lost, and that, we say, madam, is a factor of particular weight, and I've reproduced the exchange and cross-examination
Sorry,
above.
where are you looking now?
That's at paragraph 195.
I see, okay.
Madam, turning over the page, it's probably not helpful for me to just read isolated parts of this, but you see, madam, we've dealt with the Batchild London Road assets in these paragraphs.
Okay.
And I'm going to turn over the page again to page 74. We have a discussion of the Tenham assets.
Okay.
Over the page, on page 76, we have the southern scheme and its impact, which, as I said, we consider in three tranches. So we start in the north around Rodmersham Church Street. Page 78, we have the assets in Rodmersham Green Conservation Area. And finally, we have Bexon Court. And given that my leader has read out the impacts on the Kent Downs national landscape, and this interacts with those harms, I propose to read this out. The setting, I'm now on paragraph 222. The setting of this Grade 2 listed Wealden Hall house includes its verdant garden, open rural landscape, and visibility from surrounding lane. It enjoys visual and historical connections to the surrounding agrarian landscape. The proposed development will have a harmful impact on that setting, primarily through the construction of a new elevated road junction to the northeast adjacent to the listed building. Whilst the M2 motorway is an existing feature, it is in a cutting which diminishes its visual and oral presence. The environmental statement recognises this, describing the motorway as a peripheral feature to the north, screened by planting at the road edge. And I just intervene to note that that may be of relevance to the other matters that you have to consider, madam. It also recognises the openness at the junction between Bexon Lane and Hawks Hill Lane, which provides panoramic views of the surrounding rural landscape and from which the additional junction would likely be perceived. And that quote, madam, comes from the same paragraph as the environmental statement in the sentence before. The junction will, in addition to introducing built infrastructure, bring further detractors such as vehicle movement, lighting and noise, disrupting the appreciation of the rural buffer between the house and the M2. And woodland screened planting intended to mitigate the highway's infrastructure impact will itself distract from the building's open outlook and agrarian context. Conclusion. On a prosaic level, the heritage assessment above informs the matters on which you, madam, and thereafter the Secretary of State, must, by statute, give great weight. But more fundamentally, we say, the exercise serves as a yardstick of the extent to which the applications sap at the sense of place around Sittingbourne. As with the landscape, the overall heritage harm, which Swells says cannot on balance be justified under the tests in the framework, means that the applications conflict with this chapter, as we explore in the planning balance. The schemes are contrary to the placemaking principles underpinning the local development plan, which seek to preserve the historic and special interests of rural areas and its landscapes. We return to this point in the planning balance. Sure. Madam, I have a correction to make. You asked me about paragraph 177, just underneath. The correct difference of judgment between the parties is as follows. So Miss Soanes is indeed medium to high. Dr. Mealy is not at high, he is at medium. And this you will find in the Statement of Common Ground, which is at core document 34.8.1 at page 30.
Okay, thank you very much. So are we correct then when we come down to the...
So, Madam, we would be correct when we come down to that passage, because the point remains that he is the only expert to this inquiry putting forward a medium harm, and that is correct.
Yeah. Okay.
Whereas Dr. Doggett, Heritage England, they all consider the harm to be high, but Miss Soanes, to be clear, she considers the harm to be medium to high. She's in between.
Okay, that's fine. Thank you.
Thank you very much, Madam. Turning now to the effect of the proposals on ecology, including protected habitat sites and ancient woodland. This is also a chapter that I propose to speak to and draw out the main points for the planning balance. Chapter 15 of the framework seeks to conserve and enhance the natural environment. At a decision-making level, it seeks to protect sites of biodiversity value, to provide coherent ecological networks which support priority species, and to integrate biodiversity improvement into its design. The sheer scale of the application means it might usefully be compared to the framework's overall vision for plan making, and indeed Mr. Baxter considers the compliance of the scheme against those policies in his proof of evidence. Under those ambitions, plans should safeguard wider wildlife networks and wildlife corridors and the stepping stones that connect them. The southern scheme as a whole is evidently contrary to many aspects of the overall vision of this chapter. Madam, we've already gone through the significant landscape harm. We will also advert to the loss of best and most versatile land and its wider benefits. These are addressed elsewhere. This section focuses on what can be considered the flora and fauna of ecological concerns, but they are only a segment of this chapter's overall vision. Madam, I summarise the common ground between Swirl and the applicants. There's common ground on European sites, so essentially the HRA test, in the sense that we defer to Natural England as statutory consultee. We agree that the schemes are both capable of reaching around 20% biodiversity net gain. We agree that the loss of habitats in the local wildlife sites, Highsted quarries, can be compensated by on-site replacements. As I explained there, the Swirl's concern relates principally to the severance of the local wildlife site to the ancient woodland to its south. We are agreed that all recreational pressure on all habitats can be adequately managed through mitigation measures. We accept it's not unlikely that Natural England would refuse to grant a species licence, but it doesn't address our concerns on fragmentation for the reasons that we address below. And finally, Madam, everything in this chapter relates to the southern scheme. We divide our ecological concerns in two, which we address after some overall comments. So in terms of the overall observations on the ecological evidence, which I will canter through, Madam, you will recall at the beginning of the cross-examination with Mr. Baxter, I identified the extent to which the scheme relies not only on mitigation, but on compensation. So reading at paragraph 229C, I say, as such, the scheme relies heavily on compensation to address all of SBC's concerns. It is essential to the success of the scheme overall that the compensation is of a sufficiently high level and adequately maintained for its overall ecological ambitions to be realised. Continuing at paragraph 230, more broadly, the mitigation and compensation is not purely ecological. It will perform multiple functions, being both green infrastructure and biodiversity corridors. Its delivery is central to the applicant's overall promises of providing what Mrs. Brockhurst has built as a new places with new characteristics and qualities that will become valued by the people who use the spaces. Second, in paragraph 231, we note that although the mitigation is merely illustrative, Mr. Baxter accepted that the mitigation as proposed today was very complete, and I also reproduce the fact that he accepted in cross-examination that what was put forward today was likely to come forwards. And third, I'll read this out in full. The parties are agreed that there are two respectable bodies of professional opinion on the ecological issues before the inquiry. It is the case that Miss Forster did not undertake a site visit, and there is no point to be made here. Why? Because in her judgment, with the benefits of over 17 years as an ecologist, she did not consider a site visit necessary. And, we note, Miss Forster was never challenged on this point. It was never put to her that the discharge of her professional obligations required a site visit. Now turning to ancient woodland. As ancient woodland takes hundreds of years to establish, they constitute an irreplaceable habitat. There is perhaps surprisingly a welter of opposition to the southern scheme on account of its loss of ancient woodland from Natural England, the Woodland Trust, Kent Wildlife Trust, and the Forestry Commission. In terms of the direct loss of ancient woodland, the scheme will result in the loss of around 4% of Highsted wood, which is judged to be of overall high quality. And as an irreplaceable habitat, the harm to Highsted wood is a generational loss that will not be recovered within our lifetime, those of our children, or indeed our children's children. In terms of indirect loss, ancient woodland can be harmed through means other than direct loss, and the indirect loss is addressed in the standing guidance at core document 20.13. And what follows, we go through 4 aspects of that indirect loss. Firstly, there is the separation from the local wildlife site as a result of the road, and we address that further in the section on ecological connectivity, so I'll leave that there. Turning now to the operational impacts, Swale shares the Woodland Trust concern at the extensive built infrastructure in close proximity to the ancient woodland and the intensive uses of that land. The sheer extent of the development is remarkable, and this is perhaps best seen in Figure 8, which extracts various plans that are before, draws various plans that are before the inquiry together. It would flank Highsted Wood on all sides, with housing estates to its west, south, east, and northeast. The area adjacent to the housing estate on the south is designed to be an active recreational zone, which is in purple, articulated around a secondary access road, and a further active recreational cordon is planned to its northeast. The road infrastructure to its north, itself a source of disturbance, is bounded by an active, sustainable movement corridor. Likewise, but to a lesser extent, Bex would be bounded to the south by commercial operations, to the east by the Southern Relief Road, and to the north by an informal recreational zone. We draw this together on the diagram over leaf. And going over to page 88 on paragraph 238. I'm just turning the page, madam. The meagre 15-metre buffer proposed around Highsted Wood is inadequate to guard against these indirect harms on 2 counts. First, madam, we note that the buffer only applies to the housing development. There's no formal buffer put forward to the Southern Relief Road, despite the road's obvious sources of noise, emissions and light. Mr. Baxter's answer to this in cross-examination was that, well, a greater buffer would require more encroachment into the ancient woodland. That may be so, but the consequences of the indirect effects of the Southern Relief Road are inadequately mitigated. Second, the 15-metre buffer is the minimum recommended in the standing guidance. The mitigation will, I quote, depend on the type of development, and its size and type depends on the scheme. Particular factors justifying larger buffers are where the site is less densely wooded and close to residential areas, both of which would apply here. Simply put, it is not credible to suggest that a scheme of such scale, intensity as proximity to Highsted Wood ought to be providing only the minimum 15-metre buffer. Continuing with paragraph 239, we say these points carry over to the recreational pressure, which I note is accepted, can be mitigated, but it will need sustained, well-funded and carefully managed intervention if the ecological integrity of the woodland is to be preserved. 240. Cat predation. The extent of cat predation is disputed. Unsurprisingly, given the predictive assessment, Miss Forster has not provided any specific figure. Mr. Baxter's ultimate figure turns on a series of 5 assumptions, but each link in the analysis has a margin of error, and the overall margin necessarily amplifies along that chain. The point remains that cats, on the evidence, are major predators of wildlife in Britain. They are the most abundant carnivores globally and have an immense ecological footprint. The only study for which the underlying data has been provided to this inquiry bases its assessment on prey brought home to the cat's owner and is therefore likely to be an understatement. Its data, and I quote from the article, represents the minimum number of animals killed by cats and shows kills for dormouse, long-eared and pipistrelle bats, and lizards. The use of bells on cats, an inquiry favourite, might reduce kills, but it would not likely protect birds or herpetofauna, as bells do not affect their kill rates, and it would be a whisker too difficult, if not outright unbelievably difficult to police. Finally, the cumulative impacts. The Woodland Trust has helpfully summarised the risk posed to ancient woodland by what it terms cumulative development, particularly when roads and housing are delivered in combination. I summarise where I'm getting the quote from, and that document notes that the cumulative impacts are the least studied and are hard to quantify. The report dedicates a section to the cumulative impacts of road and urban development, highlighting the combined effects of noise, light, vehicle emissions and barrier creation, all of which tend to generate indirect and incremental harm to highly disturbed patches within the landscape matrix. And what I will do is I will just refer to the underlined part of this study. So, for example, it refers to the Link and McDermott study in 2012, which discusses an area which had a road built and then houses were added at a later date. And then going to the final sentence, which is underlined, where it says the fragmentation effects of these patches on the ecosystem are not well understood, as each disturbance is viewed in isolation from existing disturbance. The Secretary of State is in truth being asked to authorise a sequence of intrusions into the landscape around and in Highsted Wood, with the road being delivered first and Highsted West coming forward in phases. The risks must not themselves be fragmented. The indirect harm is incremental, compounding and difficult to reverse. This concern put to Mr. Baxter in cross-examination is shared by a number of consultees. Madam, at paragraph 245, I go through why it is not accepted that there would be a benefit to the ancient woodland in that it would no longer be surrounded by fields in intensive agricultural use. I say there is no evidence regarding the current baseline of fertiliser use. Second, I refer to the study that has been put in evidence by Mr. Baxter, which shows the rapid rate of drop-off once you go past the field on which the fertiliser is spread, and in C, draw attention to the overall impacts on the Highsted Wood in any event, which would need to be considered in the balance, even if the argument is accepted. As for the compensation scheme, given its importance, I will read this out in full. The compensation scheme is set out in the Ancient Woodland Assessment and involves the following three elements. Madam, I go through this in the planning balance, but just to be perfectly clear, it is accepted that the compensation scheme itself does comply with the framework as Mr. Dygan expressed, just to like that. Maintenance and enhancement of the existing ancient woodland would obviously be welcome, but it would need to be adequately funded and appropriately secured. It is also a benefit that does not strictly require the loss of 4% of the ancient woodland in order to come forwards. Translocation of soils. As accepted in cross-examination by Mr. Baxter, translocation is not mitigation, may be beneficial, and there is no long-term evidence supporting its efficacy. The sources that Mr. Baxter relied upon have significant caveats. Notably, the most recent study in April 2022 concluded that there was limited robust published evidence on the effectiveness of ancient woodland soils translocation. Translocation is essentially probably better than nothing, but at best no more than a salvage process for what is lost. Compensation planting. The ratio of compensation planting would appear to be high in comparison with other projects, but it is quality and not only the quantity that matters, as Mr. Baxter rightly accepted. The proposal will replace relatively high quality ancient woodland with woodland planting with a low condition even after 10 years. And two further factors show why the compensation is suboptimal. The compensation lacks the direct connectivity with the treed section of the local wildlife site, and so it will not deliver the benefit of connecting ancient woodland better with semi-natural habitat. And despite the compensation planting being identified as a primary ecological corridor and a minimal access zone, it would be bisected by an access to the neighbouring recreational sang with attendant severing effects. And so there I bring together the various plans that are before the inquiry, showing those points. Ecological connectivity. At the heart of the difference between the parties is whether the Secretary of State's expectations that the schemes maintain the coherent ecological networks is fulfilled. The importance of connectivity is well recognised in national policy. It is of particular importance in Swale, where fragmentation is, and I quote, a large issue. Ms. Forster explains that the site currently has ecological connectivity through woodlands, hedgerows, and the arable or orchard fields, and its potential is well established. As explained by Ms. Forster in chief, and recognised in the environmental statement, the local green grid strategy recognises that it sits in a north-south wildlife corridor. Plainly, the scheme will adversely impact much of the current and potential ecological network. For example, the scheme as a whole will remove 25% of the existing hedgerows, for which Mr. Baxter accepted in cross-examination were a valuable habitat network. In addition, the road, by its very nature, the applicants recognise, will sever or form a barrier by cleaving the site in two. Indeed, the environmental statement actually relies on that severing effect to conclude that there will be no adverse recreational impacts or urbanisation effects on the local wildlife site. And the replacement of networks of arable fields by a housing estate will necessarily limit the ecological legibility of the site. The attractive suggestion that the loss of ecological connectivity could be redressed either through mitigation or compensation is an easy one to assert in the abstract, but it must be tested in practice. Madam, we give 2 examples of the ecological fragmentation, which I don't propose to read out. The first example that is given, went through with Mr. Baxter in cross-examination, is the link between Highsted Wood, so the ancient woodland, and the local wildlife site. And I've adverted to that previously, but that's essentially set out there. But I'll just flag that I do point out at paragraph 252, the Keepers of Time document explains essentially the benefit of connecting ancient woodland to other woodland, even if that other woodland is of, is semi-natural woodland, so, like the trees that have been there for, less than 20 years. That's the first one that we draw attention to. The second is the severing impact between Highsted Wood, which is ancient woodland, and Cromer's Wood, which is also ancient woodland. And I draw together the various plans there. Madam, essentially, if you look at the plan on the left, you have H55, which is the hedgerow, which you perhaps have seen on site. Yeah. And I show what it would be replaced with and how you would actually need to get from, essentially from A to B through those 5 obstacle courses there. Going back to the text at paragraph 256, I address the Green Bridge. Much was made of the Green Bridge in the applicant's evidence. Swale is not opposed to a Green Bridge, but if it is relied on as part of an ecological strategy, it must be ecological effective and deliver the other aspirations it seeks to bring forwards. We say it is over-ambitious and likely to underdeliver for 3 reasons. The first is that the bridge serves overlapping competing demands. In Miss Ahern's words, it tries to do too much. It is multimodal, with important links for pedestrians, cyclists and cars. It is multidirectional, the main point of access to Highsted East, to Highsted West, and to one of the 2 principal accesses to the Kent Science Park. And multifunctional, because it has landscape functions too. A bridge which seeks to serve so many different interests will need to be particularly well designed and funded so that it will actually deliver them. The point was not lost in the early design stages, where Design Southeast noted that creating a meaningful landscape and ecological crossing point was worth exploring in more detail. But, it noted, a true landscape and ecological corridor across the bridge will be needed if it is to deliver maximum benefits. In ecological terms, the bridge is poorly suited to provide an east-west connection across the site to mitigate the severing effect of the road. Indeed, as Mr. Baxter recognised in cross-examination, the Green Bridge provides no direct connectivity between the east and west ranges of the site. Madam, I've just put a footnote in there. Rather than putting in yet another diagram, I'm just going to cross-refer you to the point that is made just on this point by Mr. Bamber. He makes the point in respect of pedestrians. It's just a helpful diagram in his evidence that illustrates the point that we're making here. It only connects the east and western parts of the sustainable movement corridor. For an animal to actually cross from the east to the western part of the site, it would actually have to cross multiple roads either side of it, none of which would be in ecological connectivity corridors. And the current proposals provide only 17.7 metres width for the green part of the bridge, as you see it illustrated on that page. This falls far short of what is required to ensure ecological connectivity. European and international studies generally recommend widths from 40 metres upwards for wildlife bridges and discourage, as here, widths of below 20 metres. Natural England, this is slightly incorrect, madam. It's a study that was commissioned by Natural England. It's not actually Natural England that is saying this, but the point still remains. The study commissioned by Natural England summarised their extensive review of the literature as follows, and I will read this. Bridges with aims to achieve connections at a landscape ecosystem level should be over 80 metres in width. Bridges which aim to achieve connections for species at population level should be around 50 metres. Published guidance recommendations range from 25 to 80 metres with an average of 50 metres. Bridges below 20 metres in width are not recommended as the frequency of reuse has been found to be lower. The inquiry may wish to compare the slim pickings offered here with what has been delivered elsewhere. The Scotney Castle Bridge, to which Mr Baxter alluded in cross-examination, was nearly twice the width of the present proposals and had no vehicular crossing. Madam, you get that from the documents for the inquiry. Even at outline stage, Swale has real concerns that the Green Bridge is a marketing gimmick and not a credible ecological corridor. Conclusion. The southern scheme flies in the face of the Secretary of State's expectations in Chapter 16. It destroys irreplaceable habitats in favour of low quality and disconnected woodland. It severs ecological corridors with poor substitutes in their stead. And as covered elsewhere, it substantially erodes the value quality of landscape of the greatest importance. This should not be seen as a single strike of non-compliance. Non-compliance with Chapter 16, Swale says, has stark ramifications for the consistency with the overarching principles of sustainable development on which the Secretary of State's policy is rightly founded. The purpose of the planning system, we are told, is to provide homes, commercial development and supporting infrastructure in a sustainable manner. This principle is not a goal or an aspiration. The Secretary of State expects this to actually be delivered through the applications of policies in the framework. As such, the non-compliance with Chapter 16 cannot be quarantined. It affects compliance with the framework as a whole. This holds good for the local development plan as well. The conflict with what might be seen as granular or lower tier policies that protect the natural environment seep downwards into the broader settlement strategy. Indeed, the overarching policy strategy is founded on sustainable development. Support for building outside built-up areas is contingent on complying with national planning policy, and the Sittingbourne's area strategy itself expects development to maintain landscape character and improve its condition and quality. We return to this point in the planning balance below.
I presume you will deal with the Section 106 agreements provisions relating to the national landscape compensation points, do you?
Yes, absolutely, Madam. Just to flag, sorry, I had attempted to do that. I just thought rather we would just address Section 106 altogether, but there is a lot.
Yep, there's a lot. Certainly a lot.
Yeah, there's a whole section on the protected landscapes.
Okay, fine, thank you.
So Mr Rhymes has a brief opportunity to catch his breath because I'm going to deal with the next 2.5 pages, but are you going to be okay then continuing? Yeah. Okay. So matter G, which is the effect on surrounding settlements, and this is a matter that arises directly, principally because the Secretary of State's asked about it, but in some ways it overlaps with some of the other topics such as landscape and so on. So we deal with it briefly. I won't read all of this, but I'll touch upon some points. I will read 262. A leitmotif of local planning is the preservation of separate settlements through policies that respect their individual character.
So I can't even pronounce it.
A leitmotif, it's like a theme.
A theme, isn't it?
Yeah, a theme. A recurring theme.
We need a sort of...
Need a glossary at the back.
To that end, Bearing Fruit seeks to prevent the separation of settlements through important local countryside gaps, rural lanes, and provides an overarching settlement strategy directing growth to larger urban centres and away from the smaller, more isolated settlements in the countryside. As such, the local development plan policies take stock of the character of settlements and their separation, and recognises that they should be influences upon where growth should be located. As the Council understands it, the effect on surrounding settlements question relates to the effect of the schemes on the grain of the settlement pattern. The mitigation of the impacts of the scheme more broadly is dealt with as appropriate through planning conditions and the 106 agreements. And 264, no doubt the applicants will likely downplay the harm from this coagulation of settlements, casting it as a barrier to growth, but there are a number of reasons why these policies should be given some weight. While seen in isolation, they are restrictive policies. In the context of the plan as a whole, they work hand in hand with other positive policies that seek to direct growth as appropriate to sustainable urban locations. They're directive, we would say, not restrictive. So,
Yet again. But what's a coagulation of settlements?
coalescence? Yes, coalescence would be another word, yeah.
Coagulation is usually what happens with blood, isn't it?
It does, doesn't it?
Are you sure that's the right word?
I think it can be used, even if it's...
Oi.
I think it's been used
But you
figuratively.
mean coalescence?
but we mean
anyway,
coalescence, yes.
For us simple people,
Yes.
do you? Thank you.
You won't forget it now, anyway. Secondly, preventing sprawling development is a legitimate planning objective in and of itself, and we refer to the framework there. And thirdly, the coalescence of settlements typically involves unsympathetic building out in rural areas. There we use the word coalescence there. Look. This concentrates and amplifies the harms identified to landscape, given the encroachment on sensitive character areas, and heritage, given setting harm, discussed elsewhere. And we then say we give a couple of examples of encroachment, noting that in many respects they are symptoms of other harms which have been discussed above. It's notable that the examples in the southern site are all designated conservation areas. Preserving the identity of these villages is singled out for particular protection in the planning regime. That's under the Listed Buildings Act. So for the northern scheme, we have some, we say something about Batchild and the separation between Tenham West and Tenham. For the southern scheme, we mention the Tunstall and Rodmersham, Tunstall and Rodmersham Green, both specifically identified as settlement villages and as such not part of Sittingbourne but distinct. Yes.
Sorry, another interruption. It would erode the separation of Tenham West and Tenham. Tenham West being, because that's what you've called the proposed new settlement in the north, isn't it? So I just wondered what you meant by Tenham West.
Yes.
There was such a place.
Sorry, I think that is an error. It should read, it would erode the separation of Sittingbourne and Tenham by Tenham West. Apologies, madam. Thank you.
Thank you for that.
That's all right. Thank you.
And then at B, on 267, we mentioned the Rodmersham Church Street, small settlement which originated as a farming community in the medieval period, and the erosion of that village's identity. I will then read 268 and 269. Elsewhere, it has been suggested that the schemes are extensions to Sittingbourne. The precise planning alchemy to reach that conclusion is obscure and not one that Mr. Dygan agrees with, and we respond to it below. That's in the context of the DM8 point. But if the Council's position is not accepted, and they are indeed to be understood as extensions to Sittingbourne, this exacerbates the effect of coalescence we have adverted to above. Standing back from the detail, the Leviathan scale of this scheme and its landscape impacts, which are accepted to be significant, are such that a serious impact on the existing grain of settlement seems to us inevitable. There may be a temptation to chalk this down to an inevitable feature of the ambitious growth put forward in the schemes. However, this harm needs to be recognised and fed into the overall planning balance, and it also vividly illustrates the consequences of the grievous departure from the settlement boundary put forward in the local plan. That boundary is not an abstract planning concept. It has tangible implications for the communities that have existed here, in some cases, for centuries. Thank you.
This is obviously written by you, Mr. Rhymes, I should think. Was it? Are you classic educated?
No, I think it's just like a lot of
classics.
time has been spent thinking about this, and sometimes you light upon a word and you're like, you know what, that's the right word.
So,
Or maybe it isn't the right word, but I've got
No,
to...
I'm sure it is, but to simple soul, you know.
Well, I don't know who would
Leviathan, very big.
I don't know who would be a simple soul.
Well,
yeah.
me for one. So, Leviathan is just large, is it?
Very
Yeah.
Very large.
Huge.
Could be
Yes.
huge. Very large. Huge.
Massive.
Huge. Let's say huge. Okay.
I will say there were several words I had to Google when I was checking through. So,
Well, I'm just asking.
It's
so I
not the
don't
best
have to do
synonym
that.
for large. There is a better synonym for large. It's coming on. It's,
Huge. We'll say huge, shall we?
Okay.
Yeah. All right. Thank you.
I now have another rest, and Mr. Rhymes takes over.
You're back on again now, Mr. Rhymes. Okay, thank you.
So, Madam, as you'll appreciate, all of the rest of the closings are very much, light reading. This chapter is the economics chapter, slightly more heavy going. So I will just pick out a couple of points as far as they relate to the planning balance. So, Madam, at paragraph 270, I note that Swell has not put forward an economic reason for refusal for either of the schemes. And then continuing at paragraph 271, I identify the key issues between the parties, being the immediacy of that need and the extent to which that need is appropriately met through the expansion of the Kent Science Park proposed in the Southern scheme. Swell's position is that as far as that need is concerned, Swell has a healthy 8-year supply of employment land thanks to the allocations in its current local plan. And in any event, the applications are not well suited to meet any immediate need for employment space given the lead-in times of that development. And so we address this under 3 headings. We address 3 overall themes. We address why the Savills model is flawed, which, as I explain elsewhere, is of importance for Swale given and other local authorities given the need to plan appropriately for employment need. And we also offer some comments on the applicant's approach to the following sectors. In advance, Madam, I don't propose to read out the industry and logistics sector, but I'll read out some of the research and development sectors and the concluding observations on the aspirations for the Kent Science Park. And Madam, the importance of this is drawn together in the planning balance, which we address below. Over the page, starting with national policy, we summarise in that paragraph, paragraphs 85 to 87 of the MPPF. BMV is also relevant, but we address BMV later. At paragraph 275, we make 3 observations on those ambitions, namely those contained in paragraphs 85 to 87 of the MPPF. Madam, you will recall that Mr. Pestle explained how the existing local plan delivers on the framework aspirations for a healthy pipeline of employment land. He said that the strategy presents, and I quote, a sound strategy and a sound plan in that it recognises economic shortcomings, diagnoses them, and adopts a strategy intended to address them. We say it is uncharitable and wrong to suggest that Swale is planning for continued underperformance. Madam, I then summarise in paragraph 277 the current local plan and what it seeks to do. At paragraph 278, Mr. Pestle gives in Appendix 4A his evidence of the build-outs of those allocations in the local plan. The simple point is that, as at today, much of the pipeline for employment land has not been taken up. As he explains, we do have land, but we do not have a planned period supply. The fact that there is no planned period supply is entirely anodyne, entirely normal, given that Swale is midway through its plan period. Looking to the future, I summarise the evidence of Mr. Pestle on the emerging local plan. That's at paragraph 279. And at paragraph 280, I explain essentially that, and I can read this out. If the 2023 Employment Land Review were to limit itself to previous trends, it would have provided 47.8 hectares of employment land. However, the Employment Land Review goes above and beyond that figure by including a margin, an inflated allocation, even though the existing supply is sufficient to provide for the next 9 years. This is a large margin which essentially amounts to an additional 5 years of employment land take-up. Madam, as you noted in questions to Mr. Pestle, the Employment Land Review, it should say, the Employment Land Review could have simply drawn from allocations later in the plan period, but it did not and chose a path of more ambitious growth. In cross-examination, Mr. Pestle was criticised for not referring to paragraphs 85 to 87 of the MPPF. In particular, it was suggested that he had focused overly on the floor of meeting business needs and not the ceiling of wider opportunities for development. However, as he explained in response to that question, the ambitions in the MPPF are reflected through the local plan and the emerging local plan evidence base, which set ambitious growth patterns. Second, in terms of the location of employment land, throughout the inquiry, the applicant's evidence has been at pains to downplay not just the prospect of an enlarged KSP failing as a commercial venture, but the relevance of the same in planning policy. To close this point, the applicants often rely on the term Wider opportunities in paragraph 85 of the MPPF focus not, they say, on local business needs, but on the wider opportunities for development. Taken to its logical conclusion, building anything anywhere, even if it is bound to fail as an economic venture or otherwise poorly located, would of itself be compliant with the applicant's vision of Chapter 6. Very little economic development would not fit within the ample cloak of the wider opportunities for development. This locational agnosticism, basically not caring where anything is built, relies on an isolated phrase in paragraph 85 and would be contrary to the framework's overall vision of sustainable development, which we say is clearly expressed in Chapter 6. Going over the page to paragraph 284, Mr. Dobson offered a counterpoint to this approach. His approach in chief was that the existence of competition is not a reason to suppress growth. Such pure capitalist ideology has evident appeal, not least when expressed so elegantly, but we do not consider that to be correct when the framework is read as a whole for the reasons which we have given. And in any event, the logic certainly does not add up for the Kent Science Park. It sits in the setting of the Kent Downs National Landscape, which it harms. The site-specific policy in Regen 4 safeguards the site for science park use, not industry and logistics, and the housing estates which are proposed to surround it. Leaving the expansion of Kent Science Park to brute market forces alone will more likely involve it being taken over in large part by I&L operators rather than complementary uses. This risks compromising the setting of the national landscape without realising the policy ambitions of Regen 4 to develop the science park offering. And Madam, we address that further in the planning balance because I'm aware that there's obviously a condition that was discussed. Third, timing. Whether Swale has an immediate need for employment land is ultimately an arid point. As Mr. Pestle explains, Highsted cannot address immediate need in any event. That is because the employment offering in the Southern scheme could only come forward after the construction of the Southern Relief Road. This simple fact harks back to the truth, already made plain in 2019, that the most significant risk for the Southern scheme relates to the timing, cost and delivery of Junction 5A. This built-out is covered in evidence elsewhere. It will be at least 4.6 to 6 years before the additional employment land in the southern site will commence, and the timing of the employment land is not expected before the first 10 years of development. It is not unreasonable, we say, to take a longer-term view of how demand could be met in the light of those timescales, not least, as explained above, the implications of the development on the Kent Downs national landscape for which the junction is necessary. Now, in terms of the methodology to assess need, at first the applicants relied upon the Porter report. We are now told they do not use or cite that report. They then commissioned a yet further report, the Savills report, some 4 years after the applications were submitted to the local planning authority. This mulligan shot does little to assist their case, however, and the basis upon which need is found to exist is important to Swale, who have important work to do on their plan once these applications are determined. First, the Savills model is methodologically flawed, and we give 3 examples which I will just summarise. First, Madam, the central assumption is that if vacancy rates fall below a certain level, there is, they say, suppressed demand. And even more boldly, the extent of suppressed demand can be calculated from such vacancy. So to make that plain, where vacant floor space dips below a certain figure in a given year, that year is diagnosed as a suppressed year, and their model assumes that another business would have swooped in and occupied the floor space, but could not do so because of lack of supply. And we refer to the Warrington inspectors, the inspectors in the Warrington decision, and jumping ahead to the end of that paragraph, it says, and this is their findings, they said, attempting to quantify the scale of that suppressed demand is a complex process involving a number of assumptions, which the Savills model doesn't explain. The second methodological flaw, we go back to the logic of the model, which is spelt out in that document, and it essentially uses a suite of extrapolations from one concept to another. And just jumping to the end of that paragraph, Mr. Pestle explained that there is a link between the elements that it extrapolates from, but how you actually get from one to the other is unclear. And what is also not clear is how this process of layered extrapolation generates a sufficiently precise need figure on which any degree of reliance could sensibly be placed. The third point I will go through and I will read out in full. Third, the difficulty in linking demand for employment space from capital investment is made plain in the Savills report itself. take its assessment of research and development space, which it derives from capital investment in the research and development space. Its calculation includes investment in the renewables and clean tech sector, which forms part of the R&D space. That sector, the renewables and clean tech sector, is in large part driven by investment in a company called London Array. But London Array is a company that runs wind turbines in the middle of the sea. It only has a small office for administrative tasks in the Kent Science Park. This obviously lays bare the difficulty in extrapolating floor space need from capital investment. There may well be a conceptual link between the two, but it cannot sensibly function as a yardstick to derive a floor space need figure. But perhaps more worryingly, this example points to the overall opacity of the model. After Mr. Pestle called out the above example of London Array in his proof of evidence, which he does at paragraph 4.83, Savills produced a rebuttal, and that's appended to Mr. Dobson's rebuttal. Apparently, Savills say, the model does not attribute any research and development space demand to the renewables and clean tech sector at all. This is, of course, we say, impossible to reconcile with the plain wording of the original Savills report, but it points more fundamentally to the elasticity of the model and its lack of usefulness in accurately predicting demand. The steadfastness of its authors to defend their intellectual brainchild is understandable. That's Savills, and undermines the reliability of Savills' evidence. Of course, those authors were not called to this inquiry and do not have the heavy professional duties that come with such a task. Madam, the second point that we refer to is the fact that the suppressed demand model hasn't been used in other cases. And so we go through the fact that there was a report drafted by authors at Savills that had recommended that the suppressed demand model be adopted in the PPG, and then that wasn't adopted. We note that the approach in the PPG, and I'll just quote from there, is that specific locational requirements for specialist or new sectors, how should they be addressed? It says that these needs are often more qualitative in nature and will have to be formed by engagement with businesses and occupiers within the relevant sectors. And Madam, we say that that is precisely what Mr. Pestle is well equipped to undertake. We also give the example of the Warrington case, and Madam, just to note that in that case, the Savills model returned a need figure that was 3 times above what the inspectors actually gave thought was appropriate in the plan. And Madam, I give the paragraph references to the inspector's report there. At paragraph 291 now, the third point cannot be put more simply than to say it is just plain wrong. The suggestion of suppression cannot sensibly be reconciled with the obvious lack of demand in the market. And Madam, I'm going to read a couple of examples of that out subsequently. Paragraph 292. The nadir of Mr. Dobson's evidence was his evasiveness in answering whether he stood by the Savills model when he was cross-examined. Such equivocation is unfortunate. It was valiantly suggested in re-examination that his overall opinion did not change based on whether the Savills report was correct or not. By that point, however, the damage had already been done. Mr. Dobson expressly agreed with the patently wrong suggestion that the Savills model is widely regarded as industry best practice. He endorsed, even in rebuttal, the Savills report as reasonable and appropriate. And in cross-examination, he accepted that the primary evidence used to assess demand is the Savills report. The simple point is that Mr. Dobson's evidence to the inquiry syncs with the Savills ship, to whose mast he tied his colours. In short, the debate regarding the suppressed demand model evokes the proverbial emperor in his supposed finery, the appearance of elaboration concealing a fundamental absence. We invite you, Madam, to make plain what all others can see and reject the Savills model. Observations on particular market sectors. We go through the industrial and logistics sector. I don't propose to read that out, but essentially we say that they've overestimated the attractiveness for the I&L sector. And in terms of research and development land, at paragraph 298, we note that the applicants contend that there is an urgent and pressing need for research and development space in Kent. They point to an estimated vacancy rate of 5.5, but for the reasons that Mr. Pestle explains in his proof of evidence, that vacancy rate is mathematically impossible given the known vacancy rate at Kent Science Park and the share of employment land that it provides. And the maths Mr. Pestel goes through at paragraph 4.26 to 27 of his proof. The applicants made great play of the fact that the only formal assessment of need was prepared by then. But that does not with respect mean it is a good one or that it should be accepted. We say that the proof is in the pudding and that the demand for research and development land is simply not there. Mr. Pestel's qualitative approach, we say, coheres with the PPG and is to be preferred. Madam, essentially the way that Mr. Pestel goes about doing that is to show various research and development sites which have failed to attract interest, and I've summarised 3 of them there. So in paragraph 300A, you have the Ressa Farm site. 300B, you have Discovery Park. In paragraph C, you have Innovation Park Medway, which I propose to read out. Like Discovery Park, this is in a highly desirable location as it currently all but sits on the M2. The local planning authority sank £13 million of investment and made a local development order to stimulate its growth as a science park. The glossy master plan extolled its spirit of innovation, delivering high-value businesses attracted by strategic connectivity and an innovative environment at the leading edge. But as Mr. Pestel explained, there was virtually no interest from the market. The LDO, which is the local development order, madam, was withdrawn, and commercial advisors have suggested the park project be scrapped in favour of care homes and temporary car parking. This cautionary tale is important in 2 respects. First, as elsewhere, there is an evident gulf between ambition and delivery, but it's the second and more fundamental point that Swale wishes to emphasise. More fundamentally, the problem with the Innovation Park was not that there were planning obstacles to the delivery of its vision. On the contrary, the LDO largely simplified those obstacles. It is that there simply was not the anticipated demand for the research and development space. As Medway Council's deputy leader said, the optimistic build it and they will come approach of the last administration hasn't worked. Evidently, development at the Kent Science Park is an express aspiration of the local development plan in Regen 4, and which Swale would like to see achieved. But realism has its place. For the Austin fans, it is a truth universally acknowledged that a local planning authority in possession of a desire for growth must be in want of a science park. And so this aim has long been courted and coveted almost without exception across the country. The reality of stiff competition that the expanded Kent Science Park will face is unavoidable, and on Swale's case ought to be factored into the planning balance for the reasons that we explained below. This healthy caution is mirrored in the employment land reviews on which the applicants rely considerably to undermine Mr. Pestel's evidence. Indeed, the 2023 one noted an expansion in the life sciences sector, but observed that science parks are an ambitious but risky growth strategy for any council. And that Kent Science Park will have to compete with more well-established locations, with a stronger track record, and the infrastructure and backing to support them. This is not solved by the transformational nature of the scheme. Yes, Kent Science Park was said to need a big bang investment, but that is a necessary and not a sufficient condition. Already in 2018, the Employment Land Review considered it questionable whether Sittingbourne, even with a new junction, could compete with Ebb Street and Discovery Park for science park activity. And even then, with the new junction, the insuperable obstacle would be mopping up the demand which other authorities are so energetically seeking to curry, including those like Oxford, Cambridge and London. Within the junction, KSP would be out of the frying pan of infrastructure, but it would be in the fire of competition. That competition is, as Mr. Pestel explained, significantly stronger, not least given that the Kent Science Park lies outside areas which the new National Industrial Strategy identifies for or prioritises for life sciences development. The ambition of those 3 locations is patent. It's not made clear in the text what those 3 locations are, but it is clear in the footnote 343. Essentially, madam, it is the Greater London Authority and the Oxford to Cambridge Growth Corridor. So the 3 being referred to there is London, Oxford and Cambridge. The ambition of those 3 locations is patent. In Mr. Pestel's words, they are locations trying to grow as fast as they can in the R&D market. And I'll just draw together the evidence on those markets. London is rapidly outstripping European competitor cities, is competing with US hubs, and has lab space due to nearly double by the end of 2026, multiplied by 7 in 2032. Indeed, the breakneck speed of this monumental growth has, he explained, given rise to concern that it will outstrip demand. As for Cambridge, Greater Cambridge is one of the most desirable places in the UK and the world for both ICT and life sciences sectors. ICT is information and communication technology. The conclusion gives a vivid insight into the fierceness of the competition. Greater Cambridge has a well-established network of science and technology parks that each play a particular role in the knowledge ecosystem. Many of these is developed over several decades and provide locations of choice for business clusters that benefit from the network services and accessibility on offer. Oxford has a local industrial strategy that seeks to position Oxfordshire as one of the top 3 innovation ecosystems in the world and as a leading science and technology cluster. Where does this lead? The Council does not dispute that the applications meet the policies in Chapter 6 of the framework. It strongly disputes the reliability of the Savills model as a sound basis for assessing the need for the reasons given. It attaches positive weight to the economic benefits of the northern and southern schemes. However, it cautions over-optimistic expectations of the strategic level employment provision in the southern site for the reasons explained in evidence and summarised above. To overlook the evident competition for the R&D space will mean that there is a good chance the expanded offering will either go to INL with attendant effects to neighbouring communities or will risk remaining vacant. These will clearly have real planning harm and cannot be left to the rough and tumble of market devices, as Mr. Dobson coolly suggests.
I'm looking at the time, sorry, on the microphone. Shall we have a break there? Thank you.
So,
We will definitely finish today without a doubt, and I think we'll finish early.
about an hour, I should think, wouldn't it? Or not?
Yeah.
Where
So
you're galloping and all.
yeah, I mean, some parts again we'll read, and some parts we'll
Yes, yeah.
skip over.
You don't want to start, presumably.
No, thank you. We'd like to
Thought I'd
do
ask.
some reflecting. We need to add in all these literary references
yes, I know.
to ours now.
Well,
so
yeah, absolutely.
obviously, we're going to look like proper idiots now. But no, thank you. No, thank you for the offer.
That's all right. Right, okay then. Well, we'll have our hour. I think that's. So should we come back at 2:00? Just over an hour. Yeah. Thank you very much. For the inquiry to resume. So we're on page 115, housing next.
And
Who's reading that?
I'm reading this part.
Righty-ho.
So, matter A, whether the proposals would be consistent with the objective of significantly boosting the supply of homes in order to meet the borough's market and affordable housing need. The Council's case is that whilst the naked fact of delivering homes complies with the purpose of this chapter, the homes are in the wrong location and outside the recognised limits for urban centres in the local development plan. The thrust of this chapter recognises the importance of delivering well-located homes. As a whole, therefore, the development's contrary to the local development plan, and we would say national policy, although it complies with the chapter read in isolation. And I now really just focus on affordable housing and the DM8 point, because we accept that it will contribute to the delivery of housing generally. The parties are not far apart on the weight to be given to the affordable housing. The Council places very significant weight on delivery of affordable housing for the southern and northern schemes, respectively. The Council also accepts that the required 40% baseline for affordable housing under DM8 cannot, on the current viability, be delivered. The key issue is that the Section 106 agreements for both schemes impermissibly limit the quantum of affordable housing to a level below that which is required by DM8. That's on our interpretation, obviously. The Section 106 agreements essentially throttle the delivery of affordable housing. That currently the full amount of affordable housing required by DM8 is not viable, does not justify the ceiling in the Section 106 on that quantum, still less where it is below that required by DM8. The applicants and the Council are divided on the interpretation of policy DM8, addressed below. This dispute, of course, directly bears on the applicant's claim that the quantum of affordable housing as promised is in excess of policy requirements. It is, more broadly, an important issue for planning in Swale, as it will set the future direction for the provision of affordable housing. That's to say, not only the quantum that's delivered from these schemes, if they're permitted, but also the interpretation of the policy.
That's a interpretation.
Yes.
Right. For the courts, isn't it?
Sorry?
For the courts.
Well, it is, but you need to do it first, and so does the Secretary of State.
Well, before I get to the courts, you mean? Or the Secretary of State, rather.
Well,
I see. Okay, fine.
the principles of interpretation are not in doubt, although this is in any event a matter of law, as I think you're alluding to. First, interpretation should be straightforward. DM8 should be interpreted straightforwardly in accordance with its terms. It is a practical guide to decision-making. Parties, including developers, can expect the words to mean what they say. It is inappropriate to add glosses on those words. The more a policy is over-interpreted, the more likely the true meaning and effect, as intended by the policymaker, is liable to be lost. The siren call of lawyers who claim otherwise should be resisted. There is a risk. They seductively create the complications in the first place, only to claim some magical insights to then lead you out of them. There's a reason Red Riding Hood was warned not to venture into the woods. It may be that others of your colleagues have been led astray, but fortunately in this case, the woods and the trees are readily separated. I can claim credit for that literary reference to Red Riding Hood. No. Second, no extrinsic material. It's unnecessary and positively discouraged to engage in a process of forensic archaeology. Fossicking. I want to pause there. I hadn't heard of the word fossicking. It's, yes, well, here's something interesting. It's a word used in Australia and New Zealand, but it came across there from the Cornish miners in the 19th century. And it relates to the habit of miners that they had then, the Cornish miners, of going into old abandoned mines looking for things of value like golden nuggets and things like that. So it seems particularly appropriate to use it in this case. So it's unnecessary and positively discouraged to engage in a process of forensic archaeology, fossicking through extraneous plan-making documentation to arrive at the meaning of policy. It is only where there's an ambiguity or the policy is unclear, and that ambiguity can only be resolved by reference to supporting material, that material should be considered. This is a significant point with an eminently practical dimension. And third, we are here interpreting the policy and not redrafting it. Tolstoy's observation on unhappy families is true of the drafting of most planning policy. It is all unhappy in its own way. This is a nice quote, footnote 349. Happy families are all alike, and every unhappy family is unhappy in its own way. So, every planning policy is unhappy in its own way, but the task of interpretation is not to rewrite an unhappy policy, but give effect to it as best one can given its wording. Impermissibly, both Miss Dickinson and Mr. Bashforth, however, sought to recast rather than give effect to DM8. The applicant's revisiting of the evidence supporting the policy is a symptom of the same fault. An observer would be forgiven for thinking we were sitting at a local plan examination considering what the policy should say, rather than undertaking the much simpler task of deciding what it already says. So, we set out now our interpretation. DM8 is a simple policy. It has functionally a two-part structure. The first sets out the affordable housing target ranges by reference to a table, the DM8 table. It is that table which defines the baselines. The table's straightforward. It sets an affordable housing percentage sought in the right-hand column for the areas listed in the left-hand column. 10% for Sittingbourne Town and urban extensions and Iwade, and 40% for all other rural areas. Those are the two relevant bits for our case in the end. The second allows for modifiers. DM8 introduces flexibility by, for example, allowing for a departure in exceptional circumstances or cases of unviability, and it has a review and allows for review mechanisms. It is the interpretation of the first part that the applicants wish to be controversial, but it is straightforward. The DM8 table plainly adopts a spatial approach to affordable housing, defining the percentage sought by reference to particular areas which are defined in the right-hand column. Thus, the left-hand column of the DM8 table says area. The rows which it contains all refer to defined geographical areas or areas capable of geographical description, like, for example, the Isle of Sheppey, the strategic site at Northwest Sittingbourne in policy MU1, and so on. And the penultimate row refers to all other rural areas. This suggests that the preceding entries are also areas. On that approach, all the decision maker needs to consider is what area the applications fall within, and with the exception of the small part of the southern application site which is directly adjacent to Sittingbourne Town, the Highsted North, the remainder is all within all other rural areas, and for which the baseline is 40%. This is a simple and straightforward interpretation of the DM8 table, and even Mr. Bashforth was grudgingly constrained to concede in cross-examination there was some sense in this approach in which he sees logic. As is the case with many policies, there's considerable documentary baggage which led to their adoption. Doubtless DM8 seeks to reflect land values and other considerations so as to balance delivery and viability. But the simple point which the applicants overlook is that DM8 itself sets out how that balancing exercise is to be achieved. The viability and other somersaults that the applicants perform are unnecessary, precisely because the drafter of the policy has assessed the various considerations in the viability evidence, made various policy choices, and synthesized those choices in the appropriate contributions table. The DM8 table essentially seeks to avoid the very exercise the applicants have been at pains to undertake. This is patently clear from the introductory text of DM8 and DM8.1 itself, both of which state that provision is to be made as follows, i.e., in accordance with the DM8 table. This was the plan maker's choice, and it was found sound by the examining inspector. Miss Dickinson and Mr. Bashforth invite a wholly different approach based on housing market areas and future land values. The Council does not agree with this tortured and tortuous approach. The first and decisive point is that it is contrary to the language of DM8, and it is that language which determines its meaning. There are 4 additional reasons why it's flawed, even on its own logic. First, the locus of the housing market areas are discerned on the applicant's interpretation, not in DM8 at all, but from the explanatory text to another policy, CP3 and the CP3 table. Yet, that policy is not referred to in DM8 at all, or its explanatory text. There's no obvious connection between DM8 and the explanatory text to policy CP3. Second, more fundamentally, the argument breaks down on its own logic. If the entries to the DM8 table were intended to refer to the local housing markets in the explanatory text to CP3 and table, one would expect the DM8 areas to correspond to the local housing market areas in the CP3 table. That should say CP3. But they do not. None of the entries in the DM8 table are market areas in the CP3 table. As Mr. Bashforth accepted, CP3 refers to 3 local housing market areas: Sittingbourne, LHMA, Sheerness, Minster, LHMA, and Faversham and East Swale, rural LHMA, local housing market area. Together they're divided into 5 sub-areas. Neither the 3 local housing market areas or the 5 sub-areas are replicated in DM8. That's unsurprising, we say. Table CP3, lest we forget, is entitled "The Purpose of Housing in Local Housing Market Areas." In point of fact, the CP3 table does not even, on its own terms, define anything, let alone the entries to which table DM8 refers. This stark incongruity between the applicant's interpretation and the actual words of the plan should persuade you to turn away from the applicant's interpretation at once, rather than compliment the wolf on its teeth. Third, the end point of the applicant's interpretation is that because the combined schemes are situated in what the applicant claims are areas of low value, the more appropriate viability starting point would be 10% and not the 40%. It's precisely this kind of machination which DM8 is designed to avoid by synthesizing the viability and other metrics into a single table, DM8. But, again, it's wrong on its own logic, because the sales values, these are the applicant's sales values from its own viability assessment, on average, £390 a square foot on the northern scheme and £395 per square foot on the southern scheme, due to greater prospects of placemaking. Those are the values. That is in the upper echelon, but one. There's one level higher on the heat map, which Miss Dickinson relies upon. I did wonder whether there was something about cutting open the wolf's belly at that point, but I couldn't quite formulate it. But you can imagine it. It is, but you can imagine it for yourself, what's actually revealed when we look at the applicant's evidence. More broadly, it's difficult to see how, on the applicant's approach, policy DM8, which is essential to providing predictability on a point vital to most house builders, would fulfill its role as a practical guide to decision-making. It's contrary to its wording, as we say, the applicant's approach, illogical on its own terms, relies heavily and impermissibly on forensic archaeology, that's to say, rummaging around in the background documents. And finally, even if the applicants were right, to make good its claim that there's a 10% affordable housing baseline, they'd have to show that the applications fall within one of the 3 following terms: Sittingbourne Town, urban extensions, and Iwade. Obviously, it's not Iwade. Obviously, we're not in Sittingbourne Town, and Miss Dickinson agreed that Sittingbourne Town was the area defined in the red line policy ST3. So we're in urban extension territory. The only peg for the applicant's claim of a baseline of 10% is that the applications are urban extensions, to which entry the DM8 table refers. In cross-examination, Miss Dickinson was forced to contend that urban extensions should refer to any urban extension, wherever located in Swale. The applicants have made the same point for some time. That's obviously unsustainable, we say. We address this further below in the planning balance, but in a nutshell, it doesn't make linguistic sense. An urban extension has to be an extension to somewhere, and an extension does not exist in the abstract in a rural area. Plainly, the urban extension contemplated in that part of the table is an extension to Sittingbourne. Second, this interpretation can't be reconciled with the entry Faversham Town and urban extensions, where there's a 35% baseline. If she was correct and an urban extension were to refer to any extension, then the table would be internally contradictory. It wouldn't need to mention urban extensions again. And we'd have a problem because extensions would fall within both 10% and 35%. The planning judgment submissions concerning urban extension, that's to say, that the judgment you've got to make about whether it is or isn't one, we deal with in the planning balance section. As a final point, the Section 106 agreement provides a maximum of 27.7% affordable housing to match the assessed level of need in the 2020 HMA. Again, we don't accept that. It's a borough average, and there are known viability constraints in the Isle of Sheppey, which mean development there has a baseline of 0. Provision at the 27.7% level will not allow the borough to meet its needs for affordable housing. Miss Dickinson's attempt to shore up this point after the close of her and indeed all evidence in the Section 106 session was, we say, unfortunate. In the roundtable session, she claimed the 40% figure has no basis and is an arbitrary figure. That contention's inconsistent with her written evidence to this inquiry, which appears to accept that 40% for areas with high land values, and is in any event not how she addressed the matter in her written and oral evidence. The applicant understands full well that the 40% arises from the DM8 target and that it reflects borough need because of the differential targets across the borough as a whole. Thank you.
Madam, I'll now turn to the planning test and the planning balance, which we have divided between myself and my leader. Despite the vastness of these applications, there are two focal questions for you, Madam, and thereafter the Secretary of State, which break down into 4 issues and which I will just summarise, given that we will go through them in full. The first issue is the development's consistency with the local development plan. The second issue is its consistency with the framework and in particular footnote 7 policies. The third is whether a flat or a tilted balance would apply under the framework. And the fourth is the planning balance. Madam, you will be aware of the approach to be taken to different assets in that planning balance. They're summarised here and we go through them subsequently. Madam, you will understand that many of those issues are interlocking, and despite the length of these closing submissions, we do not address every single permutation. Turning now to issue 1, which we've defined as the proposal's consistency with the local development plan and the weights to the harms and benefits. In paragraph 323, Madam, I identify where Mr. Dygan addresses this in his proof. And at the 4th line down, I say, and I'm going to read this in full, he has interwoven the evidence of other experts for Swale into his conclusions in a characteristically fulsome and considered proof of evidence. It is not proposed to repeat that exercise here. Rather, Madam, we set out some general observations on the local development plan, which we do so first. We then essentially split the scheme into 4 different topics, which you can see under the various subparagraphs there. So we consider the housing offering, the road infrastructure, the employment offering, and the open space green infrastructure. And in each of those 4 subsections, we discuss the relative weighting that is given to them. We start with the local development plan. At paragraph 325, whether the applications are consistent with the plan, which is central to the section 38.6 exercise, depends on the policies in that plan, its overall aims, its explanatory text, and the broader principles on which it may be based do not form part of the material which Parliament has given primacy to in the statutory test. Separating the wheat from policy from the chaff of material considerations, however important they may be, is very important, not least given the impressive array of extrinsic material which the applicants have deployed in support of their case. In particular, the Thames Gateway documents and references thereto in the explanatory text, KCC's local transport plans, and the sporadic references to road infrastructure projects in the explanatory notes are not part of the plan policies for this or any purpose.
Ask actually,
Of course.
might be wrong. I probably am. But I was under the impression that there's case law that says that the explanatory text in the local plan has a similar weight to the policies, or is that incorrect?
Madam, I've put a footnote in, and it might be one of the rare occasions that the footnotes are actually helpful. It says on this, there is authority. It's the Cherkley Campaign Limited and Mole Valley. I'll just read this. It's Court of Appeal Authority, and it says, explanatory text is plainly relevant to the interpretation of a policy to which it relates, but it is not itself a policy or part of a policy. It does not have the force of policy, and it cannot trump the policy. So in other words, madam, what I'm saying that what Parliament has given statutory primacy to, if you will, it's just the policy itself. I accept that, and this paragraph is simply distinguishing between material considerations, and we accept, obviously, explanatory notes are material considerations. They also can bear on those policies, but in terms of what Parliament has actually given primacy to in that balancing exercise, it's just the policies themselves.
Okay, thank you.
Thank you. Over the page, the most important policies for determining the application are out of date, both technically and substantively. And I put a footnote there with a case explaining the distinction between the two, but we accept that it's out of date on both. The consequences that follow, however, are a matter for the decision maker. In particular, the weight to be given to the policies in the local development plan and the weight to be given to the departure from those policies is a matter of judgment for each policies. And I give a list of things that the decision maker may wish to consider. For example, the nature of the policy, the importance of what it protects, the extent to which it's consistent with the framework, and the extent to which it would justifiably or otherwise impede the provision of housing, which triggers the application of footnote 7 in the first place. We note that this does not require a uniform approach to the policies. Some may be more and others less out of date. Indeed, the focus is, of course, not whether the plan is out of date, but whether its policies are. Significant weight, we say, should be placed on the local development plan policies that protect highly valued planning assets. And madam, these are the footnote 7 policies, like heritage assets, KDNL, and the ancient woodland, because they are, we say, in lockstep with national policy. And I don't propose to read this out, but essentially this draws the analogy between what's contained in the local development plan and what's contained in the framework. And it also refers you to the appendix of Mr. Dygan's evidence, which considers each policy in a traffic light and its consistency with the framework. That is the overall approach. Now turning to the Thames Gateway. The Thames Gateway is at the heart of, or key to, the applicant's case. It forms a dominant excuse for the combined schemes being contrary to the local development plan. But this argument is, we say, a weak one. First, it proves too little. The Thames Gateway seeks to protect and enhance our natural resources, take stock of the fact that the Thames Gateway is an environmentally sensitive area, which is rich in natural and heritage assets, and recognises the value of the Kent Downs national landscape and ancient woodlands and the other ecological features that are the jewels in the crown of the Thames estuary. It is precisely not a single functional economic area, but a tapestry of places. It is the case that the site is within the area for high growth of the Thames Gateway, but that does not warrant or designate development throughout the entirety of that high growth area. Miss Ahern ably captured the point in her written evidence. She recognised that the proposed development lies within the strategy area for high growth, but that area also includes ecological designations and abuts the Kent Downs national landscape. It is not, she said, unconstrained or undesignated white land. Second, it proves too much. As Mr. Dygan put pithily in his proof, the Thames Gateway aspirations are given expression through the local development plan itself. On this, the applicants and Swale agree. Mr. Dobson, for example, calls the Thames Gateway an organising principle of the plan. The plan plainly undertakes a number of placemaking and locational choices which restrict the extent of development, even within the area of high growth of the Thames Gateway. For example, it recognises important local countryside gaps and protects specific rural lanes. I'll skip the brackets. Indeed, the examining inspector noted that the growth strategy in the plan was entirely consistent with the direction of travel suggested by the Thames Gateway. It is for that reason that appealing to the Thames Gateway to justify the extent of departure from the local development plan is, we say, misconceived. The Thames Gateway is part of the DNA of the local development plan. It is already taken into account in the plan and endorsed on that basis by the examining inspector. The applicants are, on this point, pulling themselves up by their own bootstraps. It is also for that reason that criticising Mr. Dygan for placing, admittedly in error, as he candidly explained to the inquiry, the schemes outside the Thames Gateway area for high growth in his otherwise thorough and impressive work on the committee reports, statement of case, and his proof of evidence, does not, we say, really assist the applicants. Mr. Dygan faithfully applied the policies in the plan, which include, even in this area of high growth, policies of restraint. As such, he had, we say, due regard for the principles of the Thames Gateway. And of course, as we've already explained, in terms of the Section 38.6 analysis, the Thames Gateway has no formal status as a local development plan policy. Dealing finally with the Peter Brett reports, the PBA reports, which the applicants through the inquiry have been keen to portray as giving the green light to the combined schemes. Their role has, we say, been overstated throughout this inquiry. Even the most recent report in October 2019 was confined to a high-level assessment of growth options. It specifically disavowed, so did not make, any findings regarding the site's development potential or suitability outside the plan-making context. And of course, the applicants rely upon it as a green light for their applications precisely outside that plan-making context. Its conclusions, in any event, found the scheme, even after some refinements, to be the riskiest of all four options and noted critical landscape and design concerns. To wit, the landscape was found highly sensitive and highly challenging, and its design was flawed on 10 counts, including the alignment of the bypass on the landscape and the fact that it bisects the two villages, compromising their integration and relationships. It is also fair to observe, as Mr. Dygan did, that the high-level nature of the reports is borne out by the fact that evident potential showstoppers, like habitats regulations, were not identified in their work, despite the prominence of sites of international ecological protection in Swale. Whilst they did not, in the event, stop the show, it nonetheless illuminates the light touch consideration, which is understandable given that the proposals were at an early stage. Whether it is fair to describe the work as correct by accident is for others, but the support which the applicants have often sought to curry from those reports is not, we submit, a fair reflection of their provisional content. We now proceed to assess the proposals under the local development plan, and as I've explained previously, Madam, we do that essentially in 4 tranches rather than repeat all of the evidence. So, in terms of the housing estates, paragraph 338, we say they fly in the face of the local plan settlement strategy. They sit well outside the built form of Sittingbourne, they encroach on settlements whose distinctiveness is recognised and protected in the plan, in DM 25, and as a result, they conflict with large swathes of the local development plan that seek to secure the rural qualities outside that built area, as well as the settlement boundaries which safeguard them. And in failing to preserve the valued historic assets and landscape, they are irreconcilable with both the Swale settlement strategy and the Sittingbourne area strategy. Even taking the northern application alone, the development beyond the settlement boundary results in, inter alia, harmful landscape and visual impacts, harm to the setting of heritage assets, loss of best and most versatile agricultural land, tree loss, and amalgamation of settlements. Most of those impacts have been examined under the various disciplines above. One acronym, BMV, has not. The acronym risks obscuring the reality of what is lost. Kent's fertile lands have been valued for centuries. In 1798, Edward Highsted praised the rich and fertile soils in this area, and its local community would have been involved in arable and pastoral farming, including fruit and hop growing. That land continues to be planted and pruned, toiled and worked by many hands, as in yesteryear, when oft did the harvest to their sickle yield. In more prosaic terms, there is a rich agricultural economy on both the northern and southern sites. Preserving that agricultural richness is fundamental to the plan, and fundamental to Swale's sense of place. It is in the name, bearing fruits. It unsurprisingly finds an anchor in the plan's overall statement and its core principles. Although neither of those is a plan policy, formally speaking, the centrality of this issue places into sharper relief the conflict which Mr. Dygan identifies in section 13 of his proof, and with the settlement boundaries in the plan. To that basket of harm for the southern scheme must be added the harm to the Kent Downs national landscape by virtue of the housing estate and expanded employment centre within its setting, and the other matters which we have discussed, an ancient woodland. The decision maker will need to decide what weight to be given to this overall conflict. As we explained below, there are obviously various policy tests that apply to those harms, which aren't reproduced there. But the scale of the conflict with the local development plan ought properly to be factored into that judgment. As we have explained in relation to the Thames Gateway, we explained that it has no policy force in the development plan. And fourth line down, on this point, Mr. Bashforth's case comes under strain, we say. It is difficult to understand how the applications can be contrary to both the local development plan policies and the local development plan as a whole, which he accepts, but also, as he claims, be consistent with the strategy which underpins the plan. The inherent contradictions are all the more apparent when it is considered that the Thames Gateway itself is given expression through the policies in the plan. The parties are divided on whether the applications are to be considered extensions to Sittingbourne. This is relevant to a number of issues, madam. You will note it's relevant to the settlement boundary, so we address it here. It's also relevant to the coalescence between settlements and also the application of policy DM8, which we've addressed above in matter A. Mr. Dygan has approached this question in what we say is a principled fashion, considering the physical interrelation between what exists and what is proposed. The forensic cross-examination of Mr. Dygan, asking whether separation by a road or by a couple of feet would preclude something being an extension, was respectfully unfruitful. It does not appear to be disputed between the parties that this is a question of judgment. Swale submits that overindulging the functional relationships or shared services, as the applicants do, risk overextending the term extension. Such an elastic approach does not sit well textually, the notion of an extension to somewhere having a physical nexus with the thing that is extended, or purposively, the settlement boundary policies like ST54, for example, seeking to restrict development to areas in reasonable proximity to existing built form in the local plan. On that approach, save Highsted North, none of what is proposed is an extension to Sittingbourne. Indeed, if anything, the northern site is an extension to Tenham, not Sittingbourne. Whilst this reflects the reality on the ground, it also unsurprisingly reflects the intent of the designers, master planners, both in the early stages, promising a necklace of villages and not an extension to Sittingbourne, and in the design and access statement. And we provide some reference points to the design materials on that point. The northern site is described as an urban extension to Tenham that seeks to secure a gap to Sittingbourne. On the southern site, we are told that the design seeks to be separated in the main from Sittingbourne. It is founded on garden city principles, which by definition do not set out to be a new discrete settlement and, I quote, not an extension of an existing town or village. And tellingly, the sole part of the southern site which is described as an urban extension to Sittingbourne is Highsted North. We consider that the master planning material on this issue is illuminating and undermines the applicant's contention that the settlements are in fact extensions to Sittingbourne. If we are wrong on that, however, that should be carried through to the applicant's case as a whole, in particular to the coalescence of settlements. It means the residents are well placed to fear what Councillor Speed, who is here today, described in his proof of evidence, reporting on what local residents have said. And one local resident said, we'll become just another suburb of Sittingbourne with nothing to distinguish us. Neither the northern scheme nor the southern scheme, save Highsted North, therefore can seriously be described as an extension to Sittingbourne, at least not without compromising the design principles upon which the schemes were designed. And Madam, I'll skip over paragraph 350. Turning now to weight. And Madam, you may wish to make a note. When I'm describing weight, I'm referring to the weight to be given to market housing. This is what follows. As for the weight to be given to market housing, we say that Mr. Dygan's assessment of significant weight, as opposed to very significant weight, is a reasonable one. Stepping back, of course, Madam, when assessing weight, you'll need to consider both the benefits and also the harms. And it was just to note, not to double count anything, but Mr. Bashforth in chief was at pains to explain that significant of the housing benefits came from the scale of the housing that is proposed. But Madam obviously would be aware that the scale of housing has harms which need to be factored into the balance as well. Leaving that point and now turning to the benefits which are placed upon the market housing, the following 4 paragraphs encapsulates why Mr. Dygan has given significant as opposed to very significant weight. These 4 factors include, at A, the council has, in round terms, a 4-year housing land supply. Its housing delivery test, published in December 2024, returns a healthy 122%. 51% of the intended dwellings for the planned period have been constructed in the first 10 years. There is, Mr. Dygan explains, a strong indication that the existing plan strategy will continue to perform well against its historic housing target. And there is a significant amount of dwellings that have gained planning consent but have not yet been built out. In April 2024, this totaled 53.4% of the local plan target. It is, of course, the case that we do not know how many will actually be delivered in the planned period, as was accepted in cross-examination, but this reiterates the indication that the existing plan strategy will continue to perform well against its historic housing target. Madam, I recognise that much can be quibbled with the above. In particular, the situation will change once the standard method for a housing assessment comes into force, and to which Mr. Dygan refers. One rapidly enters the realms of quantum mechanics of 5-year housing land supply and exits the realm of practical decision-making, we say. But Mr. Dygan's assessment of weight as significant rather than very significant is a reasonable one in the circumstances and is commended to you, Madam. Mr. Bashforth said in chief that he did not understand, and I quote, why. It says MS, but that's the abbreviation for Mr. Dygan. Why Mr. Dygan had factored in the extent of 5-year housing land supply. It is well established that the extent of shortfall can be considered when determining the weight to a proposal's benefit in increasing the supply of housing. Indeed, of course, with other material factors, and I put some footnotes to case law there. Indeed, that you consider the extent of shortfall when considering the benefit is a point which the courts have found to be, and I quote, obvious. We say that Mr. Dygan's approach is entirely orthodox, and Mr. Bashforth's confusion on this point, respectfully, is not well placed. In terms of the road infrastructure, the course principle of A. Sittingbourne Northern Relief Road has policy support in the plan through the policy of search AS1 and in ST5-3. Mr. Dygan has explained that Swale has deferred to KCC for expertise on the desirability of that road in highways terms, and so we do not dispute the benefits as assessed by KCC of the road infrastructure in highways terms. But the detail of the road falls to be assessed in accordance with the fine policies in the plan. The plan does not itself dictate any particular route, dimensions or details for the Northern Relief Road. Indeed, it expressly refrains from doing so to allow for the widest consideration of route options possible and deferring consideration of the same to the review of the local plan. The suggestion that the harm to the Tong Conservation Area or Frognall Farmhouse, or indeed any of the other harms, is a done deal must therefore be resisted. It remains the case that as of today, it is unlikely, for a variety of reasons, that any other configuration for the Northern Relief Road will come forwards. Yet the alternatives remain factually feasible, and Swale has gone to considerable lengths to allow them to come forward in practice. Madam, you've been taken to the configuration of the Trentport application as an example of that. The applicants in re-examination, Mr. Bashforth was at pains to emphasise that other options are not realistic, but his assessment in chief that the delivery of the Northern Relief Road in this location is necessarily contemplated by the local plan is respectfully not correct. The plan does not sanction the landscape and heritage harm that is to come about through the road infrastructure proposed in the applications. On the contrary, read as a whole, it conditions its acceptability on passing the relevant planning policy tests, into which the benefits of the road Swale accepts ought to be factors. And as we've explained previously, reliance on policy AS1 is only as good as far as it goes. The principle of road infrastructure in this area is generally supported by Policy AS1, but that is not what the combined schemes proposed. The housing estate and employment land necessary to fund that infrastructure on the northern site cannot be shoehorned within the scope of that principle. As Mr. Dygan rightly notes in his proof, the support for the Northern Relief Road was never predicated on the basis that it would need to be supported by the development of up to 1,250 homes and associated development over considerable areas of BMV and countryside. This nuanced weighting of cost and benefit is reflected in the political resolutions made by members. They supported the principle of the Northern Relief Road, and indeed the Southern Link, when it was proposed to be publicly funded, but not when their delivery was predicated upon cross-funding from housing estates. Whilst the road will bring benefits, and its status is established as far as the Northern Road, as a Relief Road, is concerned in the plan, that policy support should not, it is submitted, be exaggerated. As for the Southern Relief Road, it is accorded an acronym in the glossary, but appears only a couple of times in the explanatory text in general and aspirational terms. Going on, as Mr. Dygan rightly notes in his proof, there is barely slender support for the Southern Relief Road in the local development plan. Its route is not safeguarded, there are no policies that require or even encourage its provision, and it is not included in Swale's infrastructure delivery schedule. There is no policy support which can be drawn for the Southern Relief Road in the plan, although, again, its desirability in highway terms is left to others. KCC's local transport plans are prepared under separate legislative powers, not the Planning Acts. The most recent LTP, the abbreviation for Local Transport Plan, was adopted when KCC did not support the Southern Relief Road. That local transport plan offers generalised support for the potential new highway routes between the A2 and M2, and the local transport plans are not blind to environmental constraints, which include the rich history and distinctive environment, including the Kent Downs and High Weald national landscapes. While Swale's position is that the Relief Road meets an identified strategic need, that is not one which can be clothed with any support in the text of any particular policy in the plan. It might be overlooked, given the length of cross-examination on this point, that Matt Dygan has placed significant weight on the benefits from infrastructure, both for the northern site and the southern site. He expressly and repeatedly drew attention to the statement of common ground with KCC on the benefits of the road infrastructure in his proof of evidence, of course, before he was cross-examined. He has, loyal to Swale's case, deferred to the expert consultees on highways matters within their expertise and integrated those conclusions into his planning balance. Moving on to paragraph 366. As he raised in cross-examination, however, the other benefits of the road ought not to be overplayed. He fairly noted that there is no specific study linking the benefits of the road infrastructure to any given overall economic benefit or quantifying such a benefit. Going on to paragraph 367. And as for air quality benefits, the applicant's own environmental statement, for example, identifies for the vast majority of receptors that the improvements will be negligible for all assessed particulate matter with a smattering of beneficial receptors. And madam, I refer to in the footnotes where you can find that. Indeed, for the Southern Relief Road, both benefits and adverse effects were identified. Giving this air quality benefit significant positive weight, as Mr. Bashforth does, is not, Swale says, a tenable one. And of course, there are other harms from the road which will need to be factored into the decision. Turning now to the employment offering. As noted above, Swale has never put forward an employment reason for refusal, either under Regen 4 or otherwise. And, madam, we do not suggest that the proposals are contrary to what is contained in Chapter 6 of the framework. The economic benefits of the construction scheme, pardon me. Today, the economic benefits of the construction of the scheme are largely agreed. The dispute centres on the benefits from the operation of the Southern scheme. And even on that issue, madam, the applicants and Swale are not far apart. For the northern site, limited positive weight is given to the provision of employment for that development. And I'll just summarise the sub-paragraphs that follow. Essentially, the economic benefits of construction are largely generic ones, apart from the construction of the road. The 1 hectare of employment space is contrary to the local development plan and leads to the loss of BMV. And of course, the lion's share of that site is at the pinnacle of the BMV hierarchy, with 87% being grade 3A. As for the southern site, Mr. Digan places moderate positive weight on the economic benefits, and Mr. Bashforth very substantial weights on the same. Mr. Digan's evidence draws on the following features. First, as explored above in Matter B, Swale currently has a healthy supply of employment space around 8 years. The employment need is not acute, and that need can be met through alternative allocations as agreed by full council. And the language here needs to be modified, and which might not result in the harm to the Kent Downs national landscape and to ancient woodland. Second, Regen 4 requires redevelopment of the Kent Science Park to be for uses compatible or complementary to science park uses. For the reasons given by Mr. Pestle and explored above, the development of the KSP as a science park is much more open to question given the large developments for which it would compete. This is significant on 3 policy fronts. First, Regen requires the uses, as we have explained, to be complementary or compatible or complementary with science park uses. Second, it would not, as Mr. Digan explained in cross-examination, be desirable in placemaking terms for heavy industrial operations in close proximity to residential communities. And third, other town centre uses might conflict with the restrictions on such uses outside town areas in Policy DM2. Third, the economic gains ought to be seen in the light of the fact that there is an existing functioning economy and the loss of the agricultural economy caused by the application on most versatile land. There can be no compensation for this particular loss. The quaint community orchards proposed in the scheme cannot seriously substitute for this working agricultural economy. I've adverted to this previously, but part of the applicant's answer to this point lies in the conditions. It is accepted that there is a degree of control over the employment mix because it requires the approval of an employment delivery strategy. But it is not a real answer to Swale's case. The strategy needs to have regard to the spatial principles in the Employment Area Master Plan strategy, but that document contemplates broad E, B2 and B8 use throughout the 4 parcels of employment land. It is fair to note that the hotel is confined to one particular parcel. I just put that in a footnote. The condition offers little scope for control, given that the principle of such indiscriminate use throughout the parcels appears to have been established, and in any event, a degree of realism is required. Given the lack of imminent demand for science park use at the KSP, for reasons which we have given above, it might prove difficult to insist that it develop as a science park. Either it is constrained to genuine science park use but remains empty, or is allowed to develop as logistics as infrastructure. INL, that should read. Or it is allowed to develop as INL with attendant harm to the policy aspirations of Regen 4 and the surrounding residential amenity. Absolutely, madam. I realise it's INL. Yeah, it's, I think, industrial and logistics is the full acronym. Apologies. Madam, dealing with the 4th and final tranche of the or theme of the combined schemes, the open space. It is not disputed that there is an over-provision when compared to policy requirements in the local development plan for parks and gardens and amenity green space. Mr. Digan places limited weight on the open space provision for sports and facilities for the northern site and moderate weight for the southern site. The open space provision is broken down in Mrs. Brockhurst's proof of evidence, table 7.1. As elsewhere, when conducting the balance, what is provided must not overlook what is lost. For example, vast swathes of open space in the southern site will supplant the rural context, which is central to the area of high landscape value. The formal sports and recreation areas south of Rodmersham would erode that hamlet from its agricultural setting, and the floodlit sports facilities cheek by jowl with the Kent Downs natural landscape detract from the tranquility of that highly protected asset. And of course, the green infrastructure is in no small part mitigation for the loss of ecological connectivity over the site. There are more particularly the following factors which justify the weight that Mr. Digan gives to the provision of open space and infrastructure, as he explained in his evidence. First, the benefits cannot be measured in sheer numbers. both Mrs. Brockhurst and Mr. Bashforth point to the overall figure of 700 hectares of open space, and that is in table 7.1 in her proof of evidence. But 116.02 hectares of open space are subject to minimal access zones. It is proper, we say, that this be reflected in the weighting given to the open space. And Madam, we give a couple of examples of those areas which are minimal access zones. Second, and relatedly, and this is further breaking down the overall subtraction of 116 hectares, second and relatedly, yet other areas will provide little amenity value either in practice or intent. And as an example of that, we give the planting around the major infrastructure in the Kent Downs National Landscape, and we say it cannot credibly be put forward as open space in any meaningful public sense. Third, it is open to question whether the open space is really a public benefit as opposed to a benefit for the future inhabitants, who will, it appears, be footing the bill through service charge contributions. As Miss Ahern explained, green infrastructure is not only about quantity, but about accessibility, connectivity, integration. She said they, the open space, are not accessible for people in Sittingbourne and do not truly make up for the lack of green infrastructure in Sittingbourne. This point is of particular importance given that it is Sittingbourne in particular which lacks access to green infrastructure and not the broader Swale countryside. For the northern scheme, it is noted that the Northern Relief Road would bisect the amenity space set aside for the Stones Farm development. Whilst there is open space surrounding the Relief Road, the delivery of the Relief Road would, through noise and other interference, detract from the recreational value of this land. And fifth, for the southern scheme, the applicants include as part of the overall open space the compensation planting for the ancient woodland. However, such benefits, namely the provision of compensation, should not be considered as benefits at all under the Natural England Standing Advice. And Madam, even if you are not with us on that point, even if the compensation planting is a benefit, it would come at the expense of irreplaceable habitats.
Good. Now we turn to excuse me, the footnote 7 policies. Sorry. We address below the 3 footnote 7 policies on which the Council relies. The first is relevant to both the northern and the southern schemes, and the latter 2 to the southern schemes alone. So it's heritage, national landscape, ancient woodland. All 3 of these tests pertain to planning assets of the highest order and which Parliament and the Secretary of State have singled out for particular protection. Both the national landscape and the ancient woodland policies require exceptional circumstances or wholly exceptional reasons, even for large-scale infrastructure, which by its nature can be expected to bring wide benefits. So heritage balance, first of all. Obviously, we're not repeating everything we've said, so we've tried to condense it here to some key points. The impacts on the setting of heritage assets is described in detail in Matter J. The approach is agreed. The decision maker should place great weight on the cumulative harm to the heritage assets in the northern scheme and weigh that harm against the overall benefits of the northern scheme, and likewise for the combined schemes. With a singular exception, the Council does not contend that the harm is greater than the sum of its parts, but the entirety of the harm must be reflected against the entirety of the benefits. It's an iterative individual approach of weighing the harm to a single asset against all benefit, an iterative individual approach of weighing the harm to a single asset against all benefits would obviously fail to reflect the balancing exercise required by the Act, and that's, I think, agreed between the parties. The northern scheme principally severs the Tong Conservation Area through the Northern Relief Road and supplants the agricultural setting of Frognall Farmhouse and its barn with that of a massive 1,250 strong housing estate, its last link to its farming past. The southern scheme gives over vast swathes of rural countryside to suburbia, derancinating. Don't ask me what that means, but Mr. Rhymes will know.
Uprooting.
Uprooting, there we are. Uprooting the heritage assets from the context they have been appreciated in for centuries. The impact is particularly marked for the highly graded Grade 1 listed Church of St Nicholas in the northern parts, but harm is spread throughout its middle, the Robersham Church Street, middle to high, less than substantial harm, and the southern sections as well, Bexon Court, middle, less than substantial harm. This highlights the sheer scale of heritage harm. While such harm needs to be factored into the planning balance in any event, none of that harm has the imprimatur of the development plan. Other routes for the Northern Relief Road remain technically feasible, other than through the conservation area, and the plan does not sanction the housing estate required to cross-subsidise its delivery. And the Southern Relief Road, for its part, as we've said already, has no basis in the plan at all. There is little, if any, mitigation to offset this harm, which we have considered above in relation to the individual assets. There is one element of mitigation that's mentioned. Dr. Mealy did not undertake an internal heritage balance on that. That's there's some mitigation proposed in relation to the Tong Conservation Area and the stream, leaving that to Mr. Bashforth, who certainly on our reading and listening to his evidence didn't do so either. You'll have to reach your own judgment on that. Ms. Soanes rightly concludes that the proposals for the northern and southern schemes would do very little to diminish the harm, a conclusion which is broadly shared by the applicant's own environmental statement as far as is understood. They, in large part, could not be secured as they are outside the red line and no provision is made in the Section 106 agreement for them. The overall benefits also do not justify the harm, on which great weight ought to be placed. That's what policy says. The benefits on which Mr. Bashforth relies are dealt with comprehensively above, but in summary, the benefits of housing are significant, but falls to be seen in the light of a limited shortfall from 5-year housing supply, the current healthy delivery and the overall good delivery throughout the plan. Open space is welcome, but exaggerated for the reasons just given, and the road is of course a benefit in highway terms, but itself the dominant source of much of the heritage harm. National landscape. The applicants, having coyly dodged the issue in their planning submissions to the council, now accept that there is major development in the national landscape. That was a late arrival to their case. They are right to do so. Its nature, scale and setting not only could but will have significant adverse effects on the purpose for which the national landscape has been designated. The framework provides a clear steer for refusing such major development. Permission should be refused for major development. There is, we note, a double policy lock. First, there must be exceptional circumstances, and second, the development must be in the public interest, having regard to the factors A to C listed in the framework. Thereafter, of course, the expectation of the policy is that harm to the national landscape will be given great weight. The Council's case is that the policy thresholds are not met, and we deal with the second of those points, public interest, first. There are plainly elements of the proposal that are in the public interest, but that's a capacious, a very wide term, which also includes the interest of the public in maintaining the character of highly valued landscapes and the role they play in recreational well-being. The framework test plainly contemplates both sides of the coin being considered, both what is gained and what is lost, giving that loss great weight. The balance the Council contends is against. Secondly, exceptional circumstances. Again, the Council says for this particular development, that test is not met. On the need for the development, the Council does not resile from Kent's view that the delivery of the junction is beneficial in highway terms, but there's no suggestion that the junction is required for highway safety reasons, and Mr. Bashforth relies heavily on the infrastructure unlocking the housing and employment offering. It is essential to provide the access to the 7,000 odd homes and 34 hectares of commercial development proposed on the southern application, he says. It's only appropriate to respond in kind. The housing need does not justify development in the national landscape or this particular development. As Mr. Dygan pointed out, lack of housing supply is a feature of the housing crisis generally. He was criticised on this point, but we say without foundation. The test is a broad one. It has often been held that it is lawful for the decision maker to set up criteria to establish whether the exceptional circumstances test is met. The clay of exceptional circumstances is flexible and must be moulded somehow. Whether a need is of generalised nature is plainly capable of being relevant to the overall exercise of judgment. It doesn't preclude a finding of exceptional circumstances. We accept that, but it's plainly relevant. Notably, the planning practice guidance itself recognises that housing need may not be able to be met in national landscapes, which lends credence to this approach. On housing, we refer to the overall observations on the nature of the housing position in Swale, which point away from a demand which meets the high hurdles of exceptional circumstances. And finally, it would intuitively appear that at least some of the housing could be accessed from the existing road network, like Highsted North, although Mr. Dygan candidly accepted he hadn't had the benefit of highways expertise on that point. Turning to employment land, whilst there are benefits to the employment land, albeit we say exaggerated for reasons given, there's no pressing need for this particular employment development in this location. The case for exceptional circumstances becomes even weaker when it's accepted, as it must be, that the employment benefits could not in any event meet the immediate need, given the necessary lead-in times, and the need could be met elsewhere in due course. On the cost of and scope for developing outside the national landscape, one of the tests, it is the case that the infrastructure itself could not likely be located outside the national landscape, given its nature and function. But the reason it is there is in no small part to facilitate access to the housing and employment offering in the development, and that need could be met in some other way. The environmental impacts, that's Lim C, which plainly include those to the national landscape and to its setting, are stark and cannot seriously be mitigated given the nature of what's proposed, in particular the need to fly over the national landscape to get the required height over the M2, and we've already addressed those above. Ultimately, excuse me, only the junction is in the national landscape, and we note that the exceptional circumstances test is one which is precisely designed to catch and, where appropriate, constrain major development. Road infrastructure doesn't get a free pass. There are benefits which the Council has faithfully recognised, but we say they are not exceptional. Ancient woodland. It's not possible, we're told, to fully and accurately capture the sheer range of benefits ancient woodland provides. They are vitally important for wildlife and constitute extremely important habitats for biodiversity, and we say why there. 398. The framework therefore affords it a protection almost without parallel. Its direct loss or deterioration can be countenanced only where there are wholly exceptional and not merely exceptional reasons, and a suitable compensation plan exists. As a yardstick, the only other class of assets which such high protection in the framework of assets with such high protection in the framework includes Grade 1 listed buildings, see 213b, and its protection is further underscored by the procedural protections conferred recently upon it under the auspices of the previous government, with the reference there to Miss Forster's proof. If the national landscape test is not met, and we say it's not, it's difficult to see how this higher threshold for ancient woodland could be met. We nonetheless address it out of completeness. The present scheme, big as it is, falls short of the infrastructure projects which the framework contemplates might amount to wholly exceptional reasons. These are the national infrastructures projects mentioned in the footnote 70. As with the national landscape, we stress that the Secretary of State's own policy is deliberately designed to apply rather than give a free pass to even infrastructure projects much larger than those with which we are concerned here. The road plainly does have highway benefits, but the public benefits need to clearly outweigh not just the harm, but the loss or deterioration of habitat, which is by definition irreplaceable and for which wholly exceptional reasons are required. The employment space it gives access to could, on the Council's case, be located elsewhere in due course, not least given the expected timings of the combined scheme. And the benefits housing estates to which the benefits of the housing estates to which it routes are significant, but scarcely of the magnitude required to reach the policy test. Finally, even if that test were passed, which isn't accepted, the proposed compensation planting must weigh heavily against the scheme in the planning balance. The compensation is policy compliant, but the compensation woodland will not only be intrinsically inferior to the irreplaceable resource lost, it will be of poor quality and misses out on significant ecological opportunities, which we've summarised above. It also depends on soil translocation techniques whose effectiveness is, we say, dubious, and which are at best an attempt to salvage some residual value. Issue 3, flat balance versus tilted balance. Given the lack of 5-year housing supply, it is tempting, but wrong, to consider that we are in tilted balance territory, and the question being whether the tilted balance is disapplied. The tilted balance applies if, and only if, there are no strong reasons for refusal in the footnote 7 sense. Finding a strong reason for refusal does not rob the developer of the tilted balance they would otherwise be entitled to. The tilted balance is predicated on there being no strong reason for refusal. This asymmetry is eminently justifiable because the Secretary of State wishes particular value to be placed on a select handful or basket of policies in footnote 7. The key issue is now whether the footnote 7 policies provide a strong reason for refusal rather than a clear reason in previous iterations of the framework. That's the policy change we're all familiar with. That change strengthens the presumption in favour of sustainable development, but the government has made clear still enables these key protections, that's to say the footnote 7 assets, to be fully considered and enforced where appropriate. The fundamental architecture of paragraph 11 remains. Whether a particular footnote 7 policy results in a strong reason for refusal is a matter for your planning judgment. It's implicit that any of the conflicts with the footnote 7 policies can amount to a strong reason. The draft could, but did not, build in thresholds into paragraph 11b1. For example, provide that less than substantial harm to heritage or only a small loss of ancient woodland could not amount to strong reasons for refusal. Such thresholds should not be read in by implication, so it is a matter of planning judgment. Furthermore, the drafting of 11b1 is such that all footnote 7 policies should be considered cumulatively. The question is whether the application of the policies, plural, results in a strong reason. Alone, a particular policy might not amount to a strong reason, but may when taken in conjunction with others. Mr. Dygan's view is that for the Northern scheme, the harm to heritage assets amounts to a strong reason for refusal, and for the combined schemes, any of the framework policies on the KDNL, ancient woodland or heritage would individually or cumulatively amount to a strong reason. This being a matter of judgment and the relevant footnote 7 policies being explored above, we leave that in the hands of you and the Secretary of State. Issue 4, overall planning balance. And we've dealt with this quite succinctly, having addressed in different ways the balance in the previous paragraphs. Issue 4, the overall planning balance. And now the overall planning balance. For the Northern scheme, the Council has never resiled from the fact that the principle of the relief road is a strategic aim, with lasting public gain clothed in the authority of the local development plan. But it exacts in the proposal an excessive price. The road severs time-honoured landscapes, cleaves the conservation area in two, corrodes the rural and agricultural setting of a Grade 2 star listed asset, and housing estates necessary to fund the road have no blessing in policy terms and compounds the harm. It engulfs the historic farmstead setting of Frognall Farmhouse, replaces the quiet integrity of farmland with urbanised sprawl. These aren't peripheral costs. They're losses that strike at the heart of the meaning and identity of the place itself. As night follows day, the combined schemes, with their larger land take, unsurprisingly yield greater overall benefits. But as their size grows, so does their shadow. The harm is not only extended over a greater area, but brings assets of the highest protection in planning policy terms into the fold. The development impermissibly intrudes on the Kent Downs national landscape and destroys cherished and irreplaceable ancient woodland. The policy guardrails, which are by their very nature designed to apply to large-scale infrastructure and attendant benefits, do not justify this harm. Too promiscuous an invocation of these exceptional tests denudes them of real meaning. Neither the housing need, the infrastructure case, or the prospect of employment reaches the threshold of exceptional circumstances or wholly exceptional reasons. The Council has carefully considered the benefits of the road and the housing, on which it has given substantial weight, and the employment offer. They are plainly ambitious benefits delivered by the schemes, but the cumulative damage to heritage landscape settlement form outweigh their advantages. The ambition and scale exact an unacceptable toll on the values which planning exists to protect. The schemes should be refused planning permission, not because the council has failed to see the benefits, but because they overstep the limits of what may rightly or acceptably be sacrificed in their pursuit. We turn now to the 106 contributions. I'm happy to continue, or we could have a break there. We could have a break after KDNL. I'm going to read up until KDN at the end of KDNL, and then Mr. Rhymes. No, so I'll carry on and. No, let's carry on. Let's carry on. I'll have a sip of water. So now section 106 contributions, and you had asked earlier when Mr. Rhymes was reading, are we going to address the national landscape bit? And here we go. Here we go. Here we go. I just want to say, can I say at the outset, you may wish to write this down or not, but this is one of the schemes where its planning and its design was formulated before the new duty came in, but of course its determination falls to be determined against the new duty. And so one expects in future, of course, that the new duty will be integrated from the outset into the design and consideration of impacts of schemes. But that hasn't been possible here for obvious reasons, and that's why the point's arisen in the way that it has, and the response to it's more reactionary, if you like, rather than integrated into the design. But that won't be the case for future schemes, obviously. So, section 85, capital A1 of the Countryside and Rights of Way Act 2000 imposes a duty on the Secretary of State to seek to further the purposes of the national landscape. There's no doubt it applies to the Secretary of State when determining whether to grant planning permission. And we make the following legal submissions in the light of those cases. I don't anticipate the submissions will be controversial, even if the application is. The current statutory formulation strengthens the duty that was previously there. It applies in respect of national landscape and its setting, and sees the kind of critical point, really. It's an active duty, not a passive one. Thou shalt seek to further. That's what the decision maker has to do. It requires a decision maker to take appropriate, reasonable and proportional steps with a view to achieving its stated purpose of conserving or enhancing the national landscape. The purpose requires either positive benefits or no harm to the national landscape. There is no dispute that some harm will result to the national landscape here. The Southern and Combined schemes do not therefore further the purpose, and it would seem to be self-evident. It's not enough, this really flows from point C, it's not enough that the decision maker has simply given a particular weighting to the harm to the national landscape in the planning balance. It requires more. And then a quote from one of the cases: the duty imposed by Section 1118 of the 1949 Act upon a planning authority determining a planning application requires more than merely weighing the effect of the proposed development on the Section 5.1 purposes in the overall balance. And then F, that said, the duty isn't absolute. So it goes some way, but it can't be pressed too far. It is a duty to seek to further. It does not preclude the granting of planning permission for development merely because there's some harm to the national landscape. The protected landscape duty should be read alongside and as part of the overarching duty to determine the application in accordance with the development plan. And then G, how might this play out in practical terms? One way in which the Secretary of State could show that he has discharged the duty, notwithstanding the harm, is to require the payment of compensation or mitigation to enhance the wider national landscape. By way of policy and previous decisions, we refer to the following. The basic point we say is the Secretary of State's got to be able to say, I've sought to further the purpose of the national landscape by doing this, whatever this is. That's the the thing that needs to be there. So case law, the principle of, and we're now referring to things that support the notion of requiring a payment. Case law, the principle of compensation as a means of discharging the protected landscape duties well anchored in case law. See the New Forest case. The decision maker may need to consider whether any compensatory measures are available which might offset the identified conflict with statutory purposes. National landscape policy expects that transport schemes, if unavoidable, will provide compensatory measures through benefits to natural beauty elsewhere in the national landscape. That's in the KDNL policy. DEFRA policy on protected landscape duty contemplates the avoidance, mitigation and compensation measures as part of the duty. Compensation also readily fits within the measure to contribute to the conservation and enhancement of protected landscapes wildlife, which is one of the elements a relevant authority should consider. And the previous Secretary of State applying the protected landscape duties, Miss Miller, has referred to a wide range of previous Secretary of State decisions in which the protected landscape duty has been fulfilled by compensating for the harm to the relevant national landscapes, including the Thames Crossing, I think, which concerns the Kent Downs National Landscape. And the reference there in her appendix is, in Mr. Dygan's appendix, sorry, to the material provided by Miss Miller refers to recent Secretary of State decisions. And we've summarised them here. There's the Lower Thames Crossing decision, where two forms of compensation were taken into account. National Highways provided a unilateral undertaking for £4.2 million to fund measures and projects that meet a funding criterion that primarily conserve and enhance the natural beauty. And secondly, the Secretary of State's decision found that the proposed development was such that a financial contribution was sufficient and necessary to meet the duty in this particular case. There's still, we understand, some discussions going on about the precise quantum and nature of that funding. The Rampion 2 wind farm, compliance with the protected landscape duty in the Rampion 2 decision included a national park enhancement and furtherance scheme, a key principle of which was the compensation fund to remedy areas off the national landscape. That was to the amount of £3.5 million. Luton Airport, the Secretary of State considered that under her duty, as it was then in Section 85, £250,000 contribution could be made to the Chilterns National Landscape. That's the sum that's given as an option in the Section 106, you'll see. As we say here, the lower quantum than that sought for the present applications can be explained by the fact that the Secretary of State concluded that the development would not have any direct impact on the national landscape in that case, and its impacts were negative but not substantial. So we then elaborate on this. Given all the parties accept that there is harm to the national landscape, the grant of planning permission would not and could not further the purposes of the national landscape. That seems obvious. There's clear authority on this point. That's the CPRE case. The protected landscape duty does not detract from the overarching duty to look at the development plan and consider material considerations. Indeed, the duty applies in exercising or performing functions, so it doesn't alter those functions itself. If to decode that, it really only arises if the Secretary of State's minded to grant planning permission. That's the planning function, and then you've got to see how the duty is discharged. Standing back, there are two questions to be addressed. First and foremost, a decision on whether to grant planning permission, and we say that there in A. Then secondly, in addition, the Secretary of State will, if he wishes to grant planning permission, need to consider how to discharge the landscape duty. If, as is agreed, there is harm to the national landscape, even if such harm might be considered outweighed by other benefits, or otherwise acceptable given the policy tests, the decision maker will need to show that they have done something to discharge the protected landscapes duty, it being an active duty. The Council's position is that there will be harm to the national landscape as a result of the applications, and significantly, it can't be compensated for. That being so, if planning permission is granted, one way of then showing that the active duty contemplated by the protective landscapes duty has been discharged is to provide compensation. And then, to the detail, the Council says, and you looked at this in the Section 106 session, there are two compensatory measures at a cost of £3.4 million. Those are set out in Mr. Dygan's Appendix 8 on the material produced by Miss Miller. And in summary, there's the Compensatory Landscape Enhancement Fund, which essentially seeks to offset the impacts of the development which is within the national landscape. That's based on a formula established for direct loss of land in the national landscape, which was used in calculating compensation for the Lower Thames crossing. And Miss Miller's provided a list of matters which the proposed contributions could be spent on, including, in addition to removing landscape detractors, mapping, upgrading walks, undertaking more detailed tranquility studies, and so on, which she's costed. And second is a fund to assist in mitigating indirect impacts. The detailed costings are discussed at paragraph 6.17 of that document. That's Mr. Dygan's Appendix 8. And the applicants have agreed a financial contribution to mitigate recreational use of £250,000. The Council's case is that a further cost of £202 per dwelling is required to provide a ranger-type service for a 30-year period. Again, that's all set out. The protected landscapes duty lies on the Secretary of State. What it requires will, of course, be influenced by the degree of harm found in the planning assessment, which may or may not be that contended for by either party. The applicant's proposal to either offer the full 3.4 million or the £250,000 is, we say, unsustainable because, of course, the Secretary of State may accept neither party's case or the extent of harm on the national landscape. In other words, there isn't a choice beyond those two being given. So we would suggest some flexibility is required, and if necessary, that might be achieved by reconsulting the parties after a provisional conclusion is reached. That's as may be, and it will depend upon the decision of the Secretary of State.
Just to say, we've moved beyond that in the drafting now, so there is flexibility.
Very good. Can I just read the next page, because then I hand over to Mr. Rhymes to the end, and well, that is as much as I'd like right now. If
Sorry, I was just asking whether you want a little break.
Yeah, if I just get to the end of page 152, then we get to a natural break, and yes, then Mr. Rhymes is taking over.
A short comment.
Yeah, thank you. The applicants balk at the contribution, contending it's not SIL compliant, and we say this on that. It is necessary to make the development acceptable in planning terms. It applies in respect of the function to grant planning permission. Without the compensation, no alternative action has been put forward by the applicants which seeks to offset the level of harm to the national landscape, as the council sees it, or demonstrate how the positive duty has been discharged. In other words, as yet, we haven't seen an alternative to some contribution. That's the first point. Secondly, it is directly related to the development, or we say obviously, because it relates to direct harm caused by the development and its setting, and indeed the indirect harm on the same. But of course, the indirect harm is a direct consequence of the development. And then thirdly, C, it is fairly and reasonably related in scale to the southern scheme. This is where the element of judgment will necessarily have to come in, depending on the level of harm that's identified. And no doubt that's why the applicants softened on this, and now the Section 106, we're told, will allow some area of judgment to the Secretary of State if the two amounts put forward don't find his favour. So that, in effect, summarises why we say the SIL tests are complied with. And with that, if it's a convenient time, then we can have a break.
You're talking about all 4 contributions, aren't you? I think there were 4 of them.
Yes. Yes, and there's going to be that there will. One of the challenges in this case, obviously, is that we don't know what conclusions are going to be reached on the various harms, but fundamentally, the first 2 tests are met, and then the third will turn on, because it's about the relationship between harm and what's being sought, will turn on the planning judgment about the harm.
Okay.
Thank you.
Okay, we'll just have, if everybody's all right with it, just 10 minutes then. So it's 25 past 3. So if we just have a break until, what, 25 to 4? Is that all right? Yep. Thank you. Okay, thank you. The inquiry is resumed. We just received an email from Mr. Young explaining how he's reached a conclusion from Mr. Mitford Slade's evidence. So, Mr. Simons, you'll take it on board if necessary.
Thank you. We will.
Yeah.
Thank you.
Thank you. Right, okay. So should we finish up? Who's doing that? Mr. Rhymes going to finish? Or is Mr. Pereira going to do the last bit?
To give credit to Mr. Rhymes' work, he's going to read all the way through to the very end.
Oh, very good. Right. Okay, Mr. Rhymes, off you go. Thank you.
So page 153,
Yep.
paragraph 420, contributions for NHS care. Although a highly technical issue, it remains of central importance to those within the community. And it is in many respects a keystone if the applicant's vision is to be delivered. As the NHS note in its contributions policy, the success of garden communities and large-scale development depends on timely and efficient delivery of infrastructure, services and facilities, including community, employment and environmental infrastructure to enable residents to live, work and play in resilient, well-connected and inclusive places. Paragraph 421 requires some tweaks. The contribution for primary care, i.e. GPs, is agreed, although there were outstanding points of detail to be resolved prior to the round table session. The contribution for the acute care remains disputed. As Mr. Digan signed the SIL compliance schedule certifying that the contributions were SIL compliant, we address the broad principles of the requirements, and Madam, we're going to leave the detail of the modelling to the NHS, and the sentence should conclude in its correspondence with the applicants, because obviously the NHS aren't making closing submissions. But essentially, the Division of Labourers will address the general principles and will leave their explanation of the modelling to themselves. There are two cases which I'll call Leicester and Worcestershire. They establish important principles, but the cases themselves deal with very different issues, and we examine them in some detail given the prominence that they have in the applicant's materials. First, those two cases concerned fundamentally different contributions, namely for the running costs of the relevant trusts. They were described as follows in paragraph 13 of Leicester as the costs for additional staff, drugs, materials and equipment. But no such contribution for revenue funding is sought in this case. Second, there was no evidence in either case that the relevant costs, so the running costs, could or would not be met by central funding. This requires some unpacking. The calculation of the contribution received by each trust, or more precisely, each clinical commissioning group, CCG, although they're now called Integrated Care Boards, ICBs, was based on an algorithm that factored in population change. The algorithm is described in detail in the judgments. And essentially, Madam, under that algorithm, there was a year's delay whilst the funding catches up to the new population of the development. But in both Leicester and Worcestershire, it was accepted that the clinical commissioning group could negotiate funding that did take into account such population growth without that year's delay. So there was no reason on the facts of either case to consider the acute care still compliant. It was not necessary to make the development acceptable in planning terms. The funding gap, so that 1 year, complained of was, on the evidence, something which could be plugged. Indeed, Madam, it appears that in both cases, the NHS's lawyers were positively advising the NHS Trust that, and I quote, the existence or size of a funding gap were not relevant planning considerations. So to be clear, in those cases, not only was the NHS not addressing the legal test, they were told not to do so. It is, against that backdrop, unsurprising that in both cases the requested contributions were not SIL compliant. And as we explained below, that is very different to the present case. Madam, Our respectful submission is that the issue should not be overcomplicated. The question remains whether the familiar SIL test is satisfied, which remains a matter of judgment. Neither Leicester nor Worcestershire hold that a contribution in general for acute care is contrary to the SIL test. In any event, they both relate to running costs and make no mention of capital funding. The key features of why the contributions are sought in this case are as follows, and here we summarise the NHS's material. 428A, the contributions seek to mitigate the effect of the additional population growth as a result of the applications which are not provided for in the local development plan or in NHS infrastructure planning. The closest acute district general hospital would be the Medway Maritime Hospital, providing both elective and non-elective care for the additional population as a result of the development. It is, the NHS say, perilously close to overcapacity. Currently, it is in excess of 90% occupancy of its inpatients' beds, and best practice would be 85%. The current situation is, they say, unsustainable and unsatisfactory. The contributions seek a highly specific but important demand. They seek to cover the capital costs for the delivery of additional floor space necessary to serve the additional population generated by the application. That demand arises for the reasons given by the NHS, but essentially the acute services depend on there being available beds. Where there are no beds available, waiting times are longer, and/or elective surgeries have to be postponed with detrimental overall health outcomes. To alleviate this, additional bed space is required. It is that and only that which is targeted by the contributions which are sought. No contribution is sought for staffing, day-to-day running costs, or outpatient services. Now, there is a specific costed proposal for the NHS contributions. There is, we are told, no other means of funding this additional floor space. This is, of course, a matter on which we defer to the NHS. Continuing to paragraph 49, against that backdrop, Madam, you and thereafter the Secretary of State will be invited to find the contributions SIL compliant. They are plainly necessary in order to make the development acceptable in planning terms. There appears to be no dispute that inadequate acute healthcare provision for the additional population would be unacceptable in planning terms. Mr. Dygan explained in cross-examination that the policy basis in the local development plan would be CP6. The purpose of that policy is to assist in the delivery of necessary infrastructure to support development. It requires development proposals to deliver timely infrastructure. The definition of infrastructure is deliberately broad, not exclusive, and includes local health facilities. The policy anchor for this contribution is, we say, well embedded in the local development plan, which is, on this point, in lockstep with the Secretary of State's national policy. His policy, too, expects planning to, and I quote, identify and secure the facilities needed for primary, secondary, and tertiary care, taking into account the changing needs of the population. And that is a quote from the PPG. The key issue is whether there is a funding gap for the additional floor space which is required. Worcestershire and Leicester, in those cases, the requester did not explain the existence or quantum of such funding gap and were advised not to do so. This case is very different. The written statement for Ivor Duffy, Chief Finance Officer, explains that of the 3 capital funding sources for the trust, available to the trust, none of them can provide the capital required for the additional floor space. The sources are either too small, like operational capital, which keeps existing facilities open, too big, like strategic major redevelopments, or just ill-suited, like nationally allocated funding, whose bidding criteria the required floor space would not meet. The funding required in this case, Madam, essentially falls through the cracks. The second is whether it's directly related to the development. And Madam, this issue essentially depends on the NHS's SIDM model. And just to briefly take you through the SIDM model as we understand it, first it calculates the amount of additional households as a result of the application, and it subtracts for internal migration figures in A. It then works out the population yield, from which the model then calculates the amount time spent in healthcare settings. And then in C, it leads to the footprint required to support that additional demand, for which a build cost to deliver that additional footprint can be derived. The third is whether overall the contributions are fairly and reasonably related in scale and kind to the development. We note that the SIL tests do not require a precise or mathematical relationship. This is not the language of exacting proportionality, but of fair and reasonable relation. It plainly is. The SIDM model ensures a fair and reasonable relation between the additional household as a result of the development and the additional demands on NHS floor space necessary to accommodate it. And the development is of a very kind which is likely to give rise to such development. It is a greenfield demand. Thank you very much, Madam. It is a greenfield site brought through development management and not the local plan, and which will result in at least a 17,000 strong increase in human population, and that's just for the southern site, who will by their very nature need access to acute care. At one point, the applicants appeared to emphasise that there were no other examples in Kent of there being contributions for acute care. Of course, as Lord Denning said, if we never do anything which has not been done before, we shall never get anywhere. The law will stand still while the rest of the world goes on, and that will be bad for both. In the roundtable session, they accepted that there were precedents nationally. Indeed, the NHS Trust have given one example in Kent, albeit this is subject to the Secretary of State's ratification. The importance of these precedents should not be underestimated. A planning permission granted on the back of a contribution which does not meet the SIL tests would be impermissibly bought by a contribution which was not necessary in planning terms, and the whole planning permission would be liable to be set aside. It might be thought unlikely that a developer would compromise its permission in this way by agreeing to a contribution unless genuinely satisfied it passed the SIL tests. The recent town legal letter relies heavily on the claim that there is a systemic issue at play, such that the SIL contributions are not warranted. Pithily, they say the increase in households do not generate net new population, they move it around. And we explore this argument in some detail. The systemic issue might, of course, be a good point as far as general running costs are concerned, or social welfare benefits, both of which were considered in Leicester. But the argument does not hold good for hospital floor space, which cannot move around with the population. The issue here is not a systemic one at all, like that in Leicester. There is plainly demand created by the development and for which contributions may be sought. We offer a broader point too. The systemic argument relied upon by the applicants is a self-admitted obiter, that means not binding, observation in Leicester, drawn from the officer's report in that particular case. The case itself dealing with a very different kind of contribution, as we have explained. At most, the judgment in Leicester says, obiter, again, not binding, that the local planning authority in that case was entitled to raise the possibility that this is a systemic problem in the way national funding is distributed. Where the SIL contributions meet the relevant tests as a matter of planning judgment, and the case goes no further than outlining a potential material consideration in that assessment. Yet, the applicants appear to be wielding that obiter as if it were a fourth prong to the SIL test. They suggest that wherever an issue ought be solved by government intervention or other broader macroeconomic policy, contributions will not be SIL compliant. That is, however, a serious mischaracterization of the ruling in Leicester, where, as here, the contributions are SIL compliant. It matters not that developers or others think the matter best resolved in higher political realms. Speaking of politics, whilst there is a cogent legal basis for requiring these contributions, Swale is conscious that the decision maker is the Secretary of State. It makes a nakedly political plea, directly to him, apt for this level of decision making. If the required contributions for this specific hospital cannot be or are not made available through the planning system, he needs to provide those funds through the means available to him in the corridors of Whitehall. If he claims a moral duty to build more houses, he and his colleagues have a moral duty to fund the necessary infrastructure to support it. The current government administration was elected on a platform of building more homes and saving the NHS, which their political forefathers brought forwards nearly 80 years ago. He cannot expect communities to build, baby, build without supporting their NHS services. If he does not, he might care to ask himself how Labour is living up to its manifesto promise: we have saved the NHS before, and the next Labour government will do so again. Conclusions. We have already referred to the halcyon days when the right to develop was boldly nationalised by a Labour government in the rubble of World War II. We make no apology for returning to its roots. The bill for the 1947 Act, considered the most important for a century, was introduced to the House of Commons nearly 80 years ago. It sought to build in the wake of the devastation and pity of war. But as explained when introduced to Parliament, it also sought to balance the heavy pressure on our limited supply of land, which was especially necessary in these small, densely populated islands. It recognised the need to preserve land from development. It rued how some of the most beautiful villages had been spoiled by wholly inappropriate development. It vowed to safeguard the beauty of the countryside, to prevent towns from being permitted to sprawl, and to keep the most fertile land for food and production. All of these concerns continue to resound today. We want to build, but we want to build well. As those before us recognised in 1947, these conflicting demands for land must be dovetailed together. If each is considered in isolation, the common interest is bound to suffer. The modern answer to this age-old conflict is the principle of sustainable development. That principle is not an ornament of the Secretary of State's policy, it is its bedrock. What do we learn after 16 weeks of inquiry? If we may just be indulged a final literary reference, we compare it to Tolstoy's War and Peace. Not just in length, but for other reasons too. War and Peace reminds us that history is shaped not by grand designs alone, but by the lives of individuals caught in its flow. So too in planning. Meeting a historic need for housing cannot mean abstracting from the real people who will face the proposal's consequences. One particular wisdom in that work stands out. Princess Bolkonskaya tells her brother to be indulgent to little weaknesses. Tout comprendre, she says, c'est tout pardonner. To understand all is to forgive all. This works wonders as a counsel of compassion, but in planning, it is no counsel at all. After 16 weeks of inquiry, we now understand truly what these applications entail. We understand the price they extract from our green and pleasant land. We understand the harm they visit upon our finest and most valued landscapes. And we understand the toll they exact on our shared sense of past. The common interest of which a previous Labour government spoke when passing the 1947 Act is bound to suffer under these huge proposals. And for that, the schemes cannot and should not be forgiven. We invite you, Madam, to recommend the refusal of permission for both schemes. To do so would honour the noblest of goals recognised by those who brought forward our system of planning control all those years ago.
Microphone. Completes the closing submissions for the council.
It does indeed. Thank you very much.
Thank you. Well, I'm sure you will.
I don't know about that.
Right, okay. So is there anything else before we finish today?
I don't think so.
Can you give us a clue as to how long yours is going to be?
Yeah, we think up to 4 hours overall. So
Oh, right, I see.
so it's not, you know, it's not Marici levels quite of length. But yeah, so we think
About the same as...
it's similar to my learned friends. It's actually the page count's almost identical, but we've actually done a bit more spaced out. So I don't know how it's all going to work out, but it'll be similar. So if we obviously we'll be done no problem by say early afternoonish, that kind of
Okay,
thing.
no, that's fine. I hope you put in all the little references and long words that I can.
It's gonna be a late night tonight reading some books to try and work out what we can include.
All right, thank you. Right, so we will now adjourn then until 9:30 tomorrow. Wonderful. Thank you.